My lordship, I beg to mention an item for listing. An item for listing.
Listing, give it to the courtmaster.
Lordship, there's an urgency, Lordship, for listing, Lordship. Petitioner is in jail, Lordship. Petitioner is in jail now, Lordship. There's urgency tomorrow, Lordship, finally. Much obliged, Lordship.
May I please? I beg to mention item number 15, my lord. I'm paying adjournment for this, my lord. Item number 15. Okay.
Yeah, please, your lordship. Lordship, with the consent of the other party, beg to mention item number 3. Lordship, my senior yesterday reached home by after 12 due to flood. That's why he could not prepare the well, and the matter may be fixed on Friday.
Friday we have a lot of matter. Monday. Item 3. Next on. There will be 12 on the as straightforward and constitute the petition.
Daily list item 1 for admission.
May please, Your Lordship. Lordship, kindly matter may be adjourned for 2 days.
Which one?
Item number 1.
Item 1.
What is your prayer?
Let us see. There was some query of the court. We are required to respond to some query we had on that day.
I'm sorry, my lord. Let me check it off, my lord, if anything is there. Yes.
First is whether the bail order was executed.
Let it come tomorrow, my lord, I'll get it. Please.
And the joint prayer made by the council for both sides. Just after a week.
Item 2 for admission.
Lordship may not like to take up this matter. Respondent 9 and 10 are Calcom 7 and Dalmian 7. 9 and 10.
Pardon me?
May not like to take respondent 9 and 10 is
Is it pertaining to a matter where I appeared?
Not in Dalmia case, we have appeared, Your Lordship.
No.
In this matter, you have, in this matter, no.
I did not represent.
Yes, yes.
No, technically there is no bar.
Yes.
Unless it is a matter where I had appeared earlier or had given some advice or anything like that. It's a different issue.
My lord, in this case, they have filed some affidavit, my lord. And I want to file a reply to the affidavit. my lord. I will be allowed some time to file a representative. The pollution board, control board has also filed affidavit.
If we go by that ratio, then perhaps if we have handled government brief at any point of time, we'll not be able to appear in this court, sit in this court. Only where there is a clash of interest, then we understand. Otherwise, to recuse ourselves from a matter just because of the
So you remind me if there is some.
No, I'm sorry. I'm sorry.
No, you don't have
No,
to
no,
be
don't
sorry.
be sorry.
We are not
Sorry.
it's a good thing you have mentioned. What we are saying is, if it is a matter
No,
where
that's-
the occasion to appear, definitely
No.
I have to recuse.
No.
But it could be a matter where given some opinion at some level, you find out and let me know if there was some occasion. What is this about? It's about the cement factories.
Yes,
My lord, the pollution, my lord, because of the loading and unloading by some dust materials in Sri Lanka railway station, my lord. And there has been some violation of the guideline of loading and unloading point. It should be, my lord, about 500 distance from the human habitation. That is not, my lord.
No, but the problem is, this is not something to do with this matter. See, normally, let us talk about highways. Highways are meant to divert the traffic away from civilization. You come across our state, you'll find once a highway is built, within 6 months or 1 year, you'll find habitation across in around the highway. Now, is it the fault of the highway authorities or is it the fault of some other persons, including markets? So that actually does not solve the problem for which the highway was constructed.
My lord, rightly pointed out this that point, my lord. But here in this case,
We'll examine.
loading, unloading some materials which are
No, that's what I'm
hazardous to
saying.
the human.
No, that's what I'm saying. Whether it is a case of the factory being set up in a proper industrial area where there was no human habitation expected to be around, or is it a case that it was set up within the human habitation?
My lord, cement factories are from the human habitation. Our point is loading and unloading point and the within the, my lord, Lanka railway station. Even if no habitation, my lord, the people are coming, the passengers are coming. That should not be used as a loading and unloading point. They can shift to the
Different area.
plant area also. Loading and unloading point may be shifted to the plant area where the cement factory is there. That they are not doing.
The railway is a party here.
We have also filed our affidavit, Lordship.
You wanted some time for.
My lord, we want to file a rejoinder.
How much time do you want?
My lord, 1 week.
1 week. Learned counsel for the petitioner submits that you'd like to file a rejoinder to the affidavit filed by
Filed by the, my lord, pollution control board as well as my lord, Dalmia's amendment. That's one number 10.
filed by the pollution control board as well as by the private respondents. He submits that the matter be listed after 1 week. Prayer made is not objected to by the respondents. Accordingly, the matter be listed in the week listed on 19th August. 19th August. Please give your names to the court master for respective parties.
Okay.
Item number 4 to 9 for orders.
Last time it came, if government was to file objection, the file it. We got the file. Okay.
So there is an office store in of the registry, that the copy of the objection has not been received by the registry. Or I do not know, but it has been filed. And my copy of the same was also served to a minor claim.
Second it. When was it filed?
It was filed on my lot. We received on the second.
Usually I cannot say that it is filed by somebody else.
You have a copy, give it to us, we copy it.
Yes.
We are having the copy we miss, but under one copy we are having.
I just hope there's no defect.
My lord,
I just hope that there's no defect.
but I do not know whether it is filed by somebody else, my lord. I have not filed it,
Please check up, take up after some time then.
my lord. I have also instructed my office with the whole.
Just check up because once we start hearing and then there is defect, we can't have the affidavit, then we, too bad. Please wait for some time then.
Huh? Already it is numbered minus.
The objection is filed in item number?
Four.
Item number 4.
Is meant for only
Oh,
3.
6 also, huh?
Six also.
6 also.
6 also, 4 and 6.
Nine or four.
Just give a slip so that they can
So,
requisition.
our objection already number is.
No, just highly shipping the.
Okay.
Just give a slip so that it will be easier for the court master to get it.
You have received copies of the objection, all the councils.
Yes,
All councils, you have received the objections.
yes, ma'am.
You have
Yes, we have received also.
So, should it come
Just
later?
ask somebody in your office to check up. If there's no defect, then we'll take it up.
Well.
But if there's defect, then we'll adjourn it.
It's connected to 5.
Four to 9 and supplementary 16, I think. Huh?
Supplementary item 16 for orders.
It will say.
Okay, item 10. Item 10 for hearing.
Hard other day, my lord. Hearing in this case, my lord, the petitioner as file WS, evidence in C, cross-examine. And the claim of the petitioner is very specific and clear that his father was voter in 1966 in the my lord LSC with Abhaipuri LSC and village Kahibari. Annexer E page 50. My lord. My lord. They are arguing that on the point of rebuttal evidence, and to that effect, they have relying on the judgment of this Supreme Court, 2017.
Just give a background again.
My lord.
Just give a background again.
My lord, here, my lord, the petitioner's father was voter in 1966 in Abhaipuri, in village Kahibari. Then he, in the year 1975, he shifted to Nolbari.
That is page number.
My lord, the voter list lordship will find at page 15. Page 15, vernacular at page 16. The matter tribunal also accepted the voter list of 1966. He is voter in 1985 at page 17.
Yes. Girish Chandra is your father.
Girish Chandra, my lord, Burman is my father, Girish Chandra.
Yes.
My lord, he, after shifting to Nolbari, here he purchased some land, and there are some other documents like my lord trade license, then my lord family ID card, etc. And in all these documents, his father's name is recorded, Sri Chandra. So my lord, they cannot show any documents that my father's name is written otherwise. And that is my claim, that my father is Sri Chandra, who is voter in 1966. And there is no rebuttal evidence, no denial cross-examination to my claim. So, my lord, in the light of the full-bench judgment, paragraph 117.3 and 4, my claim is to be accepted.
Your first voter list is in 1985.
85.
Where is that voter list?
My lord, at page 17, translated copy, 18 is the vernacular.
But Mr. Siddhar,
My lord.
why documents are withheld? Because you see, if your father had died, he must be have been cremated somewhere. Anywhere in the state of Assam, he is cremated. He gets a certificate of death.
My lord.
Why nothing is there? Because there is a gap. We can't fill that gap.
My father was in 66, he is voter in 1985. And they are because of shifting. And what is their material, my lord? Doubting me. That is their initial onus to prove, my lord.
No. After the several judgment of the even in the surveillance Sonwar, it is the proceeding who has to show under section 9. Nowhere it has been laid down that the state will have to lead the evidence first. That is why in
Well,
none of the cases.
I am not saying that the state is to lead evidence, but this Supreme Court, my lord, in Sarvanda Sonal 2 also, paragraph 60, the Supreme Court says that they are to collect initial materials to doubt me as initial onus. And my lord,
You see, all these days we've been asking only one question. Now, supposing there's a person who has been apprehended and on the ground that he's a foreign national and he does not say anything. Now, what can be done to get the information and to be written in the form? This is a civil proceeding. The police can't arrest him. The
My lord-
police, they can't give him a what you call. They cannot extract information from him which he doesn't give.
My
So what is wrong in the filling up the form saying no, nil?
if does not say anything, that is rightly they can proceed. But the question is whether they have approached, whether they have asked documents, whether that should be looked into, my lord. They never visit, visit the my lord, place of residence or work site, asking the persons, and that should be in presence of other person, elderly persons or any person of the locality. They have to do it in presence of that.
No,
They
it's in a, you see, only in a criminal proceeding, there's a requirement that when there is a search or seizure, there must be some eminent person present there. But otherwise, in a civil inquiry, you'll have to show us that there is a
My lord.
requirement of law
My lord, in
that the inquiry should be done in presence
football
of somebody.
judgment in the case of citizenship, that has been said.
Where is that?
Paragraph 97. Lordship may kindly have a look at.
Muslim Mandal?
Muslim Mandal, paragraph 97. Yes. My lord, may I read, my lord?
Just a moment.
Paragraph 97.
Just a moment.
Lordship will find in the middle portion. The investigating agency has to record the same in
No, how does
presence
it
of,
start? How does the paragraph start?
my lord. Fair
do you-
investigation and fair trial being the basic fundamental human right of a person, which are concomitant to preservation of the fundamental right of a person under Article 21 of the Constitution. There has to be a fair and proper investigation by the investigating agency before making a reference to the tribunal. In such investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate at the stage itself that he is not a foreigner. In case the person concerned could not be found out in the village where he is
Just a
reported to
moment.
reside.
Just a moment. In such investigation. Yes, please continue.
My lord, In case the person concerned could not be found out in a village where he is reported to reside or in the place where he ordinarily resides or works for gain, the investigating agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality, which in turn would ensure visit of the investigating officer to the place where such persons ordinarily resides or reported to reside or work for gain, and making of an effort to find him out for the purpose of giving him the opportunity to produce the documents, etc., if any, to demonstrate that he is not a foreigner. The investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation initiated after recording his statement. My lord, they are clear provision. They cannot. Therefore, the Supreme Court, my lord, in very recent case, Rohim Ali case, has observed they cannot pick a person randomly. That has been done in the given case, my lord. And my lord, when my father was tried and cremated, when this issue was not there, my lord, there should not be, my lord. When there is, I have some prima facie documents and claiming that my father was so and so and voter of 66. That should be presumed to be correct, my lord. That is the principle, my lord, laid down in the full bench decision, the preponderance of probability. It is not a criminal case, my lord. The reasonable, the street role of evidence is also not applicable in the case, my lord. This honorable court has held in the case of Idris Ali. Idris Ali does not hold us. And in some judgment, my lord, violating this principle laid down by the full bench, some judgment has been passed, ignoring the principle of, my lord, principle laid down in the full bench. Those should not be, my lord, should not be followed, my lord. Those judgments, those are erroneous judgment, incorrect judgment.
You will find it difficult to accept this proposition for a simple reason. You see, this Muslim Mandal decision came on 3rd of January 2013. In this case, the inquiry was made on 5/4/2008. So therefore, the application of a judgment cannot be retrospective. It always has to be prospective, unless the judgment so provides that it will have a retrospective effect. That's the first principle. The second is, you see, what happens is that in this case, the statement was recorded by a police officer. He is from NLB police station. Which one? NLB? NLB, I think, is in Albari police station. Now you see, after DK Basu and all, it has been ingrained in the mind of police personnel that when they are recording a statement of a person, they don't take the signature. You see, this is a practical difficulty. It's ingrained in their mind that the statements are not to be recorded, because otherwise it is hit by the section 25 to 27, where there's a protection, and also constitutional protection under clause 2 of section 20, article 20. So therefore, these are the protections which are given, and therefore it is ingrained in the minds of the police not to take signatures. Therefore, when on prospective application, we can understand your theory would be appropriate and correct, but retrospective effect to a judgment cannot be given. Here what has happened, the second point is that here on 5/4/2008, the statement of the proceeding has been recorded by the police. Therefore, this is not a case where under paragraph 97, he is not found, and the question of whether he was found or not found has to be recorded through a elderly by in the presence of a elderly person, because here he is got, the man is found, and his statement is recorded. Therefore, that part of the paragraph 97 may not have an application
My
here.
lord, as a principle, my lord, I have.
No, you see, I understand. I'm not for a time being saying that it's incorrect submission, but what I'm saying is that we find it very hard to accept it. That is the only uh, statement we are making,
My lord,
and it's a question of
my
law.
lord, it is
And-
not my, my lord.
I understand
say
you are
it is
amicus
the-
curiae.
Yeah, we are relying on the full bench decision. And
Mm.
I think full bench decision has opined so because of the 2007 Sarvanda Sunal judgment in paragraph 60. The state has initial onus to collect materials of doubt. And on suspect, my lord, everybody may be picked up on random. Therefore, my lord, to avoid the unnecessary litigation, unnecessary harassment to the poor people, this observation has been made. I think it is not incorrect, my lord.
This particular argument you can make if you have some documents now to fortify your stand, to say that these were the documents, these are documents available with me to show that there is
My
a
lord.
continuous existence.
My lord, I have produced the certified copy of the voter list of 1966,
No, not-
85.
See,
And
in the
here, my lord,
facts, kindly listen, in the facts of the case, see, you shifted to Nalbari town in 1975.
my lord,
You also deposed that you came alone. Your parents did not come.
my lord.
There was nobody from your family who was produced as a witness in support of your case. One gentleman who claimed that you were employed in his shop as a carpenter deposed.
Well.
Now, all right, before the tribunal, because of some difficulties, certain things could not be produced. But even before this court, it is expected that some materials at some level could be produced. You are an amicus, you can get in touch with
My
the
lord.
petitioner if you want.
Mr. Sikdar, it's just a thought process which is coming to our minds. You see, dehodes whatever is available, but still under the amended provisions of 6A and the amended rules, they can still make an application with the 1966 document and then apply for a citizenship.
My lord. No,
The-
my lord, I am not in touch.
No,
with the-
we understand. We are conscious of the fact that you are a amicus curiae. There's no doubt about that. So that's why we are saying we have this thought process coming out. Can we adjourn so that you can make an effort to have a contact with the people and then take this route?
Yes, my lord, that we can afford. Before that, lordship may kindly have a look at the annexer B, page 9.
So B page.
Yes, ma'am.
B page 9.
The police has inquired and verified and said that, yes, my father is so and so. Cannot be, whether it cannot be believed, my lord. It is not my witness, or supported by any other person, is border police has said.
Yes.
exhibit it.
Hmm?
Document to exhibit it.
You have to do the order. Very good.
Mr. Pai, you see this in the, we require an information as to whether this, the petitioner has taken bail and whether he is available.
This present petition,
Yes.
I can get it
By when?
by tomorrow.
Because we also want that with this information, it will be easier for Mr. Sigdar to communicate with the person. He's an amicus curiae, so therefore,
I can get it by tomorrow, madam. No issue.
okay. We are fixing it on Monday then.
Yes.
Get the information. Then we'll
Yes.
see what can be done.
Whether he is in bail and where he is residing as of now.
Huh. Mr. A.R. Sigdar, done a counsel for the petitioner. Mr. J. Payang, learned standing counsel for the for the Home Department, and Mr. R. Talukdar, learned government advocate.
Respondent number 3.
Correspondent number 3. Next para. As the learned amicus curiae has submitted that he is not in contact with the petitioner, we request the learned standing counsel for the Home Department to inquire with the Superintendent of Police within Packet Border, Command Albari, to ascertain as to whether the petitioner is on bail and whether he can be and his whereabouts are known and the present address to which he can be communicated. Full stop. Next para. The learned standing counsel for the Home Department shall send a downloaded copy of this order to the competent authority to elicit information. Next para. List on 12/8/2024. Where was the document? That exhibit 8? Where is that document?
At page 9.
Page 9.
You can do this about my parent.
Interesting.
Development.
Item 11 for hearing.
Mr. Sikdar, this in the last years, few of the orders of the Supreme Court of India on foreigners matter. Can you give us the name of the parties and citation?
My lord, the Muhimali case, already I have given.
Huh. No, because those judgments which you give goes to in the file.
My
So we
lord.
don't have a copy.
Yes, my lord.
If you can give a citation to the
My lord.
courtmaster, we can get a printout and we'll have a comparison made.
I'll.
And the relevant paragraphs,
My lord.
please.
My.
We are not in a hurry. You can do it in your leisure time.
My.
So that we can get a printout and we'll have a,
My.
we can go through it in advance. Yes.
May I please, lordship.
Lordship, may I please your Lordship. In this matter, Lordship, we were supposed to produce the records, but particularly with respect to Annexure 1 and 2, Lordship. Certificate of registration they have produced by way of Annexure 2. We are directed to produce the original records. Lordship, to that extent, we have already communicated to them, Lordship. We are yet to receive the records, original records, Lordship. And moreover, the document is very old, Lordship. It is pertaining to the year 1966, Lordship, this report. If your Lordship can allow us some more time, then we'll put all effort to trace it out. They have claimed that they have registered before the SDO
Petitioner entry with the father in the year 1964 on the certificate issued by the instructor. Of
It was way back in 1966, Lordship. Annexure 2, Lordship, will find. And this document is not very legible, Lordship.
Just a minute.
Annexure 2 as well.
I did not. He came to India.
Negative. Solution is not going to be. Not a fact.
Not a fact that I am not a citizen.
You should increase the problem of life.
Inside. Points are here. There is no mention of the names. Just said 5 members given by the police. They-
Overtaking is.
The thing is, yet of 9 now. Five to overrating is about 5 no 2 or 3 or
94 is a 25 days.
ठीक है सब 4 होते हैं इनको ये तो accompanying list to 9 maybe that is what he wanted to he filed because he has recorded the statement.
You have in possession the original document?
No.
Can you
That-
get that
that-
original document from your client?
That was proved in the original in the tribunal court, my lord.
No, no, in tribunal it says it is not proved.
But that was not in my hand.
Huh?
That original document is not in my hand.
No, it is not in your hand, but it will be in the hands of the proceedee.
Right.
You have to get it from him.
It was compared with the original in the records.
The evidence shows, my lord, that original was proved with this record.
That's right. So the original is available.
But that was available.
So
but,
you can get a copy.
But there is an overwriting. Because there is a overwriting, the petitioner accepts that his name is not there, his name was not recorded. If his name is not recorded, then he cannot demonstrate that he is a citizen of India.
The petitioner, along with his father, my lord, entered with the from Bangladesh to India in the year 1964.
Okay. It's Exhibit 7. Is there any voter list of you and your mother and father together?
No, my lord. Only when there are 4 numbers of FTKs was registered, and among these 4 numbers of FTKs, 3 numbers of FTKs was declared Indian, my lord, but the petitioner was declared foreigner.
Pardon me?
Page number, my lord, 74 to 90, my lord. That 3 orders are enclosed with the
74 to 90.
74 to 90, my lord. Those 3 orders for the mother of the petitioner and two brothers. One is for Sunil Devnath, another is for.
No, but what is the document showing that you are with your mother?
My lord.
What is this you say is not there?
In the year 1985, my lord, annexure 5. So then Devnath, my lord, put the casted the vote
Signing
with the brother.
thus evidence of fingerprints. So banking on the same is concluded. OP means the mother. Is a pretty expensive entry. Means before 70, they have come. Not a case that they are born here or naturalized. They have come. They can register. That is. That original record, if it shows the names, then this is 142. Mother's case. This is the brother's case. 344. 344.
Missing. You have any voters list with your brothers and others, other proceedings
My
in the
lord,
IMDT?
one I voter list, my lord, 1985, my lord, page number 31, annexure 5, my lord.
Page number
Page number 31, my lord, annexure 5.
31.
my lord. Santosh Devnath, my lord. Is my elder brother, my lord. And against my elder brother Santosh Kumar Devnath, one FTCAS was registered, my lord. Page number 81 to 90, my lord.
These things are not matching. You say that on 13/8/64, you were 14 years.
Right.
Correct. So that would make your date of birth when? Year of birth? In 64, you were 14 years. So therefore 1950, you were born. Where is that voters list you showed us right now?
Like
Page 32.
1985, my lord.
Page 32.
page 30, when a relevant portion is
Page 32. This is a voters list of 1985.
My lord.
1985. You are 35 years.
I am my lord 30 years, 30.
30 years, second one.
30 years.
My lord.
So there's a difference of 5 years.
My lord.
1955. This Shailen Devnath, he deposed for you as witness.
My lord.
So then Devnath, it is
So this, your elder brother,
Santosh.
Santosh Devnath,
Santosh Devnath.
did he depose in your favor?
No, my lord. Only petitioner's deposit, I believe. And he was cross agreement.
Yes, not a problem.
He accompanied his father. His father. His father. So this last line confirms that it will be not a citizen of India, but he can be by naturalization.
Yeah.
By registration.
Mr. Payeng,
Well.
you see from the records, 2 or 3 things appear. Number one, there is a first order in the first opinion rendered in the IMDT case, 344 or something. In that, the opinion was rendered. Then there are 2 other cases of the proceedings, projected brother and others. There, the finding recorded by the tribunal is that the records of the first case is missing. So therefore, if the first case is missing, it can't be, now you can't even reconstruct it.
Yes.
There's no effort made to reconstruct the records. Now that is one part. You come to page 72. A very brilliant opinion at paragraph 4. Please read it. Page 72, paragraph 4. What do you understand from that?
The certificate issued by the sub-inspector of police. That part.
Serial number 4, from the discussion of this tribunal observed, 1, 2, 3, 4,
Yes.
page 72.
From the
From
voter
the-
list of 1997, Exhibit 2, and voter list of 2014, Exhibit 3, it is seen that OP was born in 1960. His father entered in India in 1964 and registered in India in 1966. So opposite party is not a citizen of India by birth. In view
So you
of
see this, here they admit that his father entered in 64.
yes,
If that is admitted, then how do you sustain the finding?
so it can be.
The petitioner never claims that he is born in India. He said that when my father entered, I was 14 years old. Just because he was not born in India is not a ground. If the father is admitted into India in 1964, then everything else falls in place.
My lord, from, if we read the, from observation, my lord, observation 1, that from the exhibit 1, it cannot be confirmed that opposite party entered in India in
There is-
1964.
You see,
There
there
is
is a
no-
document given by the government.
Yes, no, that is, my lord,
You don't claim that the document is forged or manufactured.
let me, my lord, check it out. My lord, your lordship may kindly see, it is not saying that it is forced, my lord. The tribunal is not saying, but from the exhibit number 1, it cannot be confirmed that opposite party, that it is the opposite party, my lord. His name is not there in that list.
No, may not be, but you see, the finding is that his father entered.
That's why, my lord. The opposite party entered in India. His claim is that he entered along with father in 1964. That is his claim, my lord. So from the exhibit 1, it cannot confirm. My lord, there is no evidence of OP entered in India on or before. My lord, if your lordship, he entered along with his parents, his name should have been recorded in 1964, that document. That is the,
No,
my
no,
lord,
you
the
see,
tribunal has said.
you see, nobody will have a document of entry in 1966.
No, it's 64. my lord.
If 64 and registered in 66,
66.
they will not have a document unless he is the family member.
Yes,
And-
unless their family members, there will be. my lord,
And there are 3 proceedings against his family members.
It's different.
His father's entry is admitted. The other what you call his brothers and other opinion given, that is also not disputed.
The brother, in fact, here also the brother is also declared foreigner by this proceeding. In view of the above findings, the tribunal is of the opinion opposite party Soilendra Devnath, son of Sasindra Devnath. Yes, sorry. Soilendra Devnath, son of Sasindra Devnath, is a foreigner post 71. My lord, here, number 2, the opposite party's father name registered is citizen of India under the provision of section 5 of the citizenship, but there is no such certificate of OP. My lord, the father of the opposite party has registered himself
No,
as
no,
citizen
no.
of
You
India.
see, what is required of a tribunal? What is the opinion to be given?
My lord, whether the petitioner is a foreigner or not, or he is a citizen of India, and he is claiming that he is the son of
No,
this.
no. He is post 71.
Yes,
So post 71, how does the tribunal arrive at a finding?
from the voter list of 1997. My lord, what the tribunal is trying to say, from the voter list of 1997, if we go to the voter list and 2014, it is seen that OP was born in 1960. So if we presume that voter list of 1997, 2014 is correct, that date of birth will be sometime in 1960. That is the opinion of the tribunal, my lord. His date of birth will be sometime in 1960. Now,
That is an admitted fact.
yes, that is an admitted. Now, his father entered into India in 1964. And as per him, my lord, his father, that is the Sasindra Devnath, who has been declared Indian, according to him, entered in 1964 and registered as Indian citizen on 8/8/1966. So opposite parties notice, my lord, if he's, my lord, it should have been clarified more, because as then we have to
No,
see.
no, you can't take that plea. Come to page 83. Come to page 83. Unless you flag it to the government to have appropriate training done to this
Exhibit
members
1.
of the foreigners tribunal, these things will happen. Come to page 83. The second
Exhibit
last
2.
paragraph, as
Yes.
certificate was issued in the name of Sachindra Devnath by the sub-inspector of police so-and-so along with his 5 family members. Therefore, this is an opinion. You see, in this, the reference is Santosh
Again,
Devnath.
It's Santosh Devnath.
Santosh and his, what you call, his voter list is together.
That is the issue, my lord. That 1985 voter list was not produced before the tribunal.
Yes.
No, it was not produced before the tribunal. He has produced only 1997 voter list and 2014. That was not produced, my lord. This document, this is First time before dishonorable. What I have examined from the records in my. What he have exhibited is. The Lordship will find what he have exhibited. So I don't get it. He exhibited exhibit 1 certificate issued in the name of Father Sosindra Dipnet. Exhibit 2 97 voter list, exhibit 3 2014 voter list, exhibit 4 affidavit shown by in respect of the date of father, exhibit 4 residential certificate by Gaura.
Within how much time we can get this records ordered by order dated 27, 25, 7, 23? How much more time? Have you communicated to them?
Lordship, we have communicated.
What is their response?
What communication through which they have informed that as because registration certificate they have not in possession, so they could not furnish the instruction. So Lordship will again try to procure the records. And the certificate Lordship they have annexed with the repetition, that is not very legible. That is also creating some sort of problem, Lordship. Is a certificate of the year 1966. They are putting in all efforts, but despite of the efforts,
This 1966 is that page 16.
Yes.
16, Lordship. This document as well as the document at page 14 of. Both the
16
documents
and
are
14.
very hazy, not very legible, Lordship. This is also creating some sort of problem.
Okay.
Lordship.
Heard Mr. B. Islam Learned Counsel for the petitioner. Mr. J. Pang, Learned Standing Counsel for the Home Department, and Mr. R. Talukdar, Learned the Government Advocate.
Respondent
para.
number 5. Respondent number 5.
It's okay. Next para. The Learned Government Advocate has submitted that pursuant to order dated 25/7/2023, he has communicated to the Office of the Deputy Commissioner. You have communicated to Deputy Commissioner,
Yes, Lordship. Deputy Commissioner Borpeta.
Barpeta, for the records of the two certificates which are annexed to this writ petition as Annexure 1 and 2. Full stop. It is submitted that as the documents annexed to the writ petition are not very legible, come on. The respondent, the Office of the Deputy Commissioner, Command Albari, has not been able to track the said document, to trace out the said document. Full stop. Next one. Accordingly, we provide that the learned counsel for the petitioner shall obtain the original copy of Exhibit 1 and Annexure 1 and 2, as well as a clear photocopy thereof. So as to enable the learned government advocate to inspect the original document and transmit the clear photocopy thereof to the Deputy Commissioner, Command Albari, to obtain the records.
Lordship, it will be Borpeta.
Huh?
Deputy Commissioner Borpeta.
Deputy Commissioner Barbeta, huh? It will be Barbeta. Mr. Islam, how much time you need to get the original ones?
Short time I will inform you.
Huh?
Within short time I will inform you.
No, we have to give a date. That's why
After 2 weeks, madam.
after 2 weeks. Just next para. Give a date after 2 weeks. List on so and so for production of the original document of exhibit of Annexure 1 and 2 and a clear photocopy thereof by the learned counsel for the petitioner.
21.8. Item 12 for hearing.
Hey, please. My lord, item number 12 and 13 is mine, my lord. My lord, item number 13 may be taken up first. Item number 13.
Yes.
My lord, the petitioner's father's name is Javed Ali, a grandfather's name. Grandfather's name is Javed Ali. Grandmother's name is Shakina Khatun. And petitioner's father's name is Sober Ali, alias Safer Ali, Safer Ali Sheikh, my lord. And the petitioner's name is Rafiqul Islam. My lord, in the voter list of 1966, my lord, the petitioner's grandfather's name and grandmother's name is shown at serial number 185 and 186.
Just a moment.
Page.
Just a moment.
None appears. The date of hearing now none appeared.
Yes.
My lord, Annexure 1, page 17. The names of petitioner's grandfather, Jabed Ali, at serial number 185, and his grandmother's name, Shakina Khatun, at serial number 186, my lord. Sure. Then, my lord,
What is the document to connect you to your grandparents?
my lord. Then the 70 voter list also shown his grandfather's name, grandmother's name. Then, my lord,
But how do you connect yourself?
85 voter list, my lord. 85 voter list, page 19, my lord. Here, grandfather's name is Jabed Ali, grandmother's Muhammad Shokina. Sabir Ali, my lord, his father's name, Sabir Ali. Elias also, my lord, subsequently, Sabir Ali becomes Sabir Ali. Well, some different spelling mistake, my lord, is there.
Page?
Page 80, page 19, my lord. Voter list of 1985. Serial number 17, Sabir Ali, father, petitioner's father. And serial number 19, Rukia Nesa, is the mother of the petitioner.
Yes.
My lord. Thereafter, my lord, 97 voter list, my lord. Sabir Ali becomes Safir Ali Sheikh, my lord. It is recorded as Safir Ali Sheikh. Father's name Javed. And 97 onwards, my lord, petitioner's father's name recorded as Safir Ali Sheikh, father's name Javed Ali. Page 23, annexure 5. Voter list of 2005, along with other family members. And the petitioner's name, my lord, recorded in the voter list 2005, page 23, Rafiqul Islam, serial number 390. With his father, my lord, Safir Ali Sheikh, serial number 388. And mother, Rukia Khatun, 389, serial number. And in the voter list of 2014, my lord, also shown the name of petitioner along with his father, Safir Ali Sheikh, son of Javed Ali. Rafiqul Islam, son of Safir Ali Sheikh.
Who is Abdul Rashid?
Abdul Rashid, Safir Ali Sheikh, my lord, he is the brother of Rafiqul Islam.
Rahim Baksha.
Rahim Baksha, Safir Ali, my lord, he is also brother. Rahim Baksha.
He is also a brother.
Zafar Ali, he is also brother, my lord, younger brother. My lord, mistake, my lord, contradiction is Saber Ali and Safir Ali Sheikh, whether same person or not. That is the question, my lord. Is that if you, my lord, family members, it proves that, my lord, his father is Safir Ali terms alias Safir Ali Sheikh is the same person. And the petitioner also swear an affidavit stating that in his written statement, he also stated that. There is no, my lord, this version is not controverted by the other side, my lord. And moreover, his father, petitioner's father has given evidence as DW2, my lord. His father says that Rafiqul Islam is my son. And he was asked questions by the tribunal. In the question answers, my lord, he also answered that Rafiqul Islam is the son of Safir Ali Sheikh.
Where is that question answer?
My lord, I have not annexed, but it is in the record, my lord.
Have you checked it?
My lord, I have one photocopy, my lord. বিপরীত পক্ষ মোর লোরা হয়। I have one copy, my lord. But
We'll find it here.
my lord,
No, you're not getting it. It's not there. No, this is on which date? What is the date?
date, my lord, 10/8/2016. On, yes, 10/1/2016.
10/1.
10/8. The father says, my lord, petitioner is the son, his son. So, my lord, link up.
Oh, it's okay. It's there. Rafiqul.
Besides him, another two. Let me show then he is four sons. That would be. The people listen up. That's good. Yeah.
Page 25.
This is somebody else.
Impression is that this man is a hired father.
My lord.
The impression we are getting is that he is your
My
hired
lord,
father.
it is the findings of the landed court bill, my lord,
No,
landed tribunal.
no. You have a copy of that. You have a copy of the cross-examination by court.
My lord,
You have a copy,
yes, my lord,
correct?
yes,
Please come to page 25 first.
page 20,
25 of the brief.
my lord,
In page 25, serial number 213 is one son. Correct?
see,
Yes or no?
Rafiqul Islam,
Ha.
yes,
Yes. Then 215,
215,
Abdul Rashid.
Abdul Rashid,
Correct?
yes,
217, Rohim
217,
Baksha. Correct?
Rashim Baksha,
Ha. Now read that examination by court. He said, "Mur duta lora ase."
Rafiqul Abdul Rashid. Now, this is, my lord, I have, in his evidence, he said that he is adopted.
Where?
Okay, adopted.
Where?
In his evidence, DW2,
Where is that?
my lord. One statement is given, my lord. Exhibit 14. Furnished to person. One statement is there, my lord. I have gone through.
That is why in the written statement, there is no family tree given. Grandmother. Grandmother.
My lord, in the page 41, my lord,
Yes.
DW1, my lord.
Yes.
DW1, my lord, yes, said, page 41, last line, my lord. Last line about 3, my lord. In the aforesaid, from bottom, line about 3. In the aforesaid voter list, son of my grandmother's uncle, brother's wife, and my grandfather, and the person adopted by my grandmother, who was working as a servant, has been recorded as serial number 182, 184, and 187 respectively.
That is
Oh,
in,
that is
in
a
66.
that is in 66.
66, my lord.
And with regard to 85, 2005, there is a statement at page 6, my lord, para 6. But that is with regard to serial number 385. 385 is different person. 385 is one Kasem Ali. To that effect, he has stated the name of person who took shelter along with his family in our home for 2 years due to erosion of Manas River has been mentioned at the serial number 3.
So this third brother is not there.
Yes, not there.
The Kasem Ali, he has disowned in his DW,
Yes,
in his evidence. He says he doesn't know.
it doesn't.
Last paragraph.
We'll take a short break and come back.
My lord.
Yes, Mr. Pine.
Why not the petitioner before your lordship has to prove only one thing, my lord, if that could be proved by himself.
You just see this before you make your submissions. Yes. The yellow flag here.
Yes.
You will see the order sheet of 10-8. Which year? 10-8?
10,
Then it's 16.
16.
16.
The state is absent.
Yes.
Therefore, this examination of the DW2 is mentioned there. That means it appears that the court has examined, the tribunal has examined the DW2. Now, this is the examination.
Yes.
This is a question the tribunal should not have asked. But once the tribunal asks a question, and it's a court question, and he responds saying that the proceeding is my son,
Yes.
how could the tribunal give a contrary opinion?
Moreover, my lord, against the father, petitioner's father's no case has been.
No, that's okay. Once it is against you and it is confirmed, then maybe your father will also be next.
Father's citizen of India, sons becomes foreigner, my lord.
No, that's okay.
Yes.
But if with
And the-
this, no other view can be possible. The tribunal's view, whether this any deficiency in the evidence is filled up by the tribunal itself by asking that question.
But now the question is whether this Safar Ali, my lord, one thing that has to be examined, and in fact, even though this is accepted, now whether this Safar Ali established that he was actually the this, my lord, the whose name
But it
was
is a court
appearing in
question. Court does not doubt it. After asking that question,
No, no,
court
no.
does not doubt it. The tribunal does not doubt it. No further examination.
Yes, that is true, madam. Court has examined on the basis of examination and he himself identified as Safar Ali,
Mm.
my lord, father of the petitioner who
No,
came
no,
before
no.
the tribunal.
You see, this is a examination by the court.
Court.
It must carry some weight.
No,
Power of the court to ask questions is under 165 of the Old
Yes,
Evidence Act.
that is only for clarification he can
No, it's not called clarification. You
Yes.
read once the Evidence Act 165. There's only, to my understanding, there is only one negative clause there. And nothing else. You see this into the Evidence Act.
— 165.
Hmm.
Judge's power to question, put question or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he please.
So therefore,
in
first
any
first requirement the court in order to discover. So what is the discovery here? Discovery here is whether the proceeding is the son
Safar
of so and so. So
Yes.
therefore, this comes within the meaning of discovery.
Yes.
Now then read, continue.
relevant facts, obtain a proper proof of relevant facts, ask any question he please if any form at any time of any witness or of the parties about any fact relevant or irrelevant.
Yes. Now, fact relevant and irrelevant is in the interpretation clause. What is the
Yes.
section 5? What is relevant and irrelevant? The fact in inquiry is whether he is the son of so and so and whether he is a citizen of India.
Yes.
That is a relevant fact. So he asked this question and the man says yes. So therefore, even if there is no voters list, even if there is no other connection, in connection with the inquiry, if this question is asked, you can't escape the consequences.
Probably that is not even the findings of the tribunal. Findings of the tribunal is that, my lord, the petitioner has to prove, yes, I accept that he may be the son of Safar Ali, as stated by Safar Ali, my lord. Now, Safar Ali has to prove that he is son of, my lord, he is the, my lord, person whose name is appearing in the voter list of 1985, where it is Sabar Ali. Son
No
of
question is
Javed.
asked. No question is asked.
No, my lord, he identified himself as Safar Ali only.
Yes.
Safar Ali's existence is only from 1980, my lord, 1997. Safar Ali Sheikh, 2005, my lord.
Safar Ali, 1997.
97.
Yes.
Now, if we examine the 1997 voter list, then 2085, my lord.
No, can't accept that. Page 54 of the brief. This is page 53 is Safar Ali Sheikh,
Yes.
Yes.
para 6.
Safar Ali Sheikh. Para 6.
Para 6. That my father name is Javed Ali, son of so and so. Javed Ali, son of so and so.
And I, namely Sohail Ali,
Yes.
Safir Ali Sheikh, Safar Ali Sheikh, Safar Ali Sheikh is one and same person.
Yes. Yes. That is his statement, my lord.
But the tribunal does not ask, if the tribunal had not asked it, that question,
My lord, did this
nothing would have
fact,
gone wrong with it.
my lord, my submission is that this fact, this is a statement given before the tribunal. My lord, I have accepted. This has to be proved that he is, my lord, Safar Ali, Sabar Ali. This Sabar Ali and Safar Ali same in one person. He has to prove that, man.
We making statement, he has to prove that he is the same person. That's burden is on him.
Because if your lordship may kindly examine it for the time being, my lord, 1985 voter list. May see the 1985 voter list, my lord. We need, my lord, to that a reliable evidence, my lord, a cognizable evidence to be placed before the tribunal. And this voter list, if your lordship see kindly consider 85 and 97 voter list for the time being. 95 voter list, your lordship will find serial number 17, whom the petitioner is relying. It's Sabar Ali.
Let's take a test case. Now, a man comes to the tribunal, says that he has no document, his name is A and his father's name is B. B is a citizen of India. That's the only evidence he gives, only 5 lines of evidence. Now, if you had the tribunal not cross-examined him, or examined him rather, it would have been a different case that he has to prove, section 9.
Yes.
He has to prove. But with this evidence, let us say the tribunal asks him a question. You are the son of so-and-so? Yes. So-and-so was a citizen of India? He says yes. Then what?
My lord,
There was no evidence at all. The tribunal asks a question and makes him a citizen of India. The cross-examination is not there. The relationship. You see, this is a classic case where section 50 applies. When somebody has to form an opinion. That's why I said, I made you stop at the word discovery in 165. In 165, it is discovery, relevant, fact. So the tribunal knows what his business is. They have to detect the foreigner. And so they ask a confirming question.
it is, my lord, in fact, my submission, tribunal has to give an opinion. They are not framing any opinion, but first of all, they have to frame an opinion on the basis of materials placed before them. My lord, it is not that they will have to declare foreigner.
No, we are not suggesting that they should declare a foreigner. We are saying that the determination.
To determine an opinion, my lord, we have to examine all the materials placed before him. These set of materials placed before him, the 85 voter list, 97 voter list, my lord, whatever he stated, all given statement before the tribunal, that is the course of the record. Record says, if your lordship
The
can
tribunal could have asked the question that you have no proof of the.
definitely tribunal
You have no
could have
proof of the 4 persons being same and 1 person.
Yes, that is true, my lord. But my lord, it is the first burden of the petitioner to prove that he is the same person. The father is the same person. My lord, if your lordship may kindly see the 85, why I'm, my lord, pointing this again and again. If your lordship see the 85 voter list, it is Saber Ali. Your lordship will find son of Javed Ali, aged about 40 years. And now this Safer Ali Sheikh, who appeared before the tribunal as evidence, as witness, as DW2, he's Safar Ali Sheikh, son of Javed, not even Ali. The age in 1997 is same, 40 years. So how can the tribunal presume that both are the same person, my lord? Because in 1988 also he was 40 years. Saber Ali. It is Saber Ali in 1988. And it is Safer Ali Sheikh in 1997. And Safer Ali Sheikh, my lord, he has not given a lies in his in his deposition, my lord. He has given directly that he is Safer Ali. Your lordship may kindly see in the deposition, his directly says he is Safer Ali 60 years. He has not given any lies that he is also known as Saber Ali. He has not stated in the very when he appeared. He has not identified himself that I am Safer Ali, alias Saber Ali.
I'll tell you something elementary.
So
I'll tell you something elementary. In an evidence, You have drafted and filed hundreds of affidavits in court.
Yes.
Now, what are the statements? Please look at the affidavit and please see what are the statements which he accepts to be correct. Any affidavit, read any affidavit. You see statement made in paragraph 1, so and so, so and so, so and so are true to my knowledge.
Yes.
Paragraphs made in so and so are true to the
Best of
what you call materials available on record, which I believe to be true. And the rest are my humble submissions before this honorable court. Correct?
Yes.
That is the format. Now, in any affidavit, have you find that a person is swearing that my name given in the in the description above is also true to my knowledge?
That is not there, my lord.
Then
Yes. No, I'm saying, my
no,
lord,
no, no. You
What is-
see, the relevant fact was in paragraph 6. The
That I
inquiry says he says that my name is so and so, so and so, so and so. 4 names he gives.
my lord, my submission is that he has given the statement
No,
in his
submission is
affidavit.
okay.
No, I
I'm
understand, my
asking
lord.
you a legal question.
Yes.
The question of law is that the traveler had it not examined this person, then the burden was on them. But in the cross-examination, you see in a cross-examination, Mr. Pang,
Yes.
in a murder case, in the cross-examination, the witness says that yes, I murdered him. In the 313 statement, the person comes and says that yes, the question is whether you murdered him. He said yes, I murdered him. That's one part. The second part is that when he's cross-examined and he says, no, I did not, in the 313 statement, he says that I did not murder him. Then the burden would lie on the state to prove it.
So, my lord, the petitioner had, my submission is that what he has stated in the evidence, that is not proved by any independent witness, my lord, any independent evidence. Because
Mr.
what-
Kalida, you wanted to say something?
What's it, what I basically wanted to say about 165. 165 is basically in the nature of clarificatory.
No.
The judge has the discretion, the honorable judge or learned judge has the discretion to ask if he finds that something needs
No,
to
it's
be
not a
asked.
discretion, it's a power.
Lordship, the language is that the judge may, judge may, it's not shall or it will.
No, may is empowering. Here it is empowering
No,
at any stage.
Yes, Lordship.
So
but-
therefore, it's not dependent that that stage would come at the cross-examination. At any time,
Anytime, Lordship, anytime.
he can call a person, ask him to produce a document and
Correct, Lordship.
question him.
Correct. Now he asks something, some reply has been given. That is perfectly fine. That is there on record. But like that has to be looked into along with the other evidence. So along with the other evidence, whether this is correct or not. I mean, one statement comes from one witness that cannot be taken as a sacrosanct because that has to be, he has to prove it with other documentary evidence because that is the procedure before the foreigners tribunal. Because burden is on him. So whatever he states in the statement, that has to be proved by evidence. So no evidence is coming. That's why the learned tribunal has asked a question, but that has to be taken as a whole with
No,
all other evidence.
let me formulate it in a different way. You see, by nature, I am interactive.
That's-
I ask questions, though I am not required. I explain why I'm passing this order.
No, absolutely.
So-
That's very encouraging.
No,
for
not
us,
that,
Lordship.
not that.
That's very
Now,
encouraging.
now
for
this
us.
is only a preclude. Now you see, I do it. But what if I don't do it?
See, that is what I am saying, Lordship, because before the foreigners tribunal, the burden is totally on them. So whatever they have stated in the retail statement, that has to be proved by way of some evidence, cogent and reliable
Then
evidence.
what is the purpose
Whether
of
the evidence is
examination?
there or not.
Please explain me and the legal terms.
Lordship.
What is the purpose of examination by a court? And what is the purpose of cross-examination?
Lordship, as far as my limited knowledge goes, Lordship, what I understand is that if cross-examination is done or cross-examination is not done, then if the learned tribunal thinks that there are certain things I may ask him, but so that a witness can give me, so that like I can come to a conclusion on the basis of whatever he says. So he will take his, whatever is stated by the witness, that will be taken into account. After taking into account, but like only on the basis of his account or her account, evidence, that will not be, I mean, sacrosanct, that will not be taken as whatever he says that will be correct. But that has to be measured with all other evidences which are available on record. And that is only, in my humble submission, that is only Lordship, only to clarify certain things and like bring in certain things which are not there on record. Only to that extent, Lordship. Otherwise, Lordship, whatever is there in the written statement, that has to be proved.
The order opinion
Lordship.
reflects, the court accepts that so and so is projected as a father,
Yes.
although with different names. So, and it begins that from the record it appears. So there has been a projection of the fathers.
Yes,
Father.
projection is there.
Right. And some voters list have been submitted in
Correct.
support.
That is there also.
Now, once a question is put to the witness, and he gives an answer saying that, yes, he is my son, and I have so and so son. That completes the linkage.
I mean,
My lord, in fact, the tribunal has not doubted the linkage with Safar Ali. In fact, the opinion also says,
Right.
Safar Ali said, tribunal has not doubted. Only tribunal's opinion is that whether Safar Ali,
is the same person.
Safar Ali, who is shown to be father of the petitioner, and Saber Ali, who is there in 1985, and who is shown to, appearing along with projected grandfather in 1985.
Who was the person examined?
Safar Ali. That's why I'm saying, my lord. It's not, had
Safar
it
Ali
been
Sheikh.
Saber Ali, my lord, that would have been a different case. But it was the Safar Ali was examined, not Saber Ali. Safar Ali Sheikh.
Sabir Ali and Safir Ali.
He doesn't say anything about Sabir Ali in his statement. He specifically says his name is Safar Ali.
What is Exhibit 9?
Exhibit
Identity card.
identity card.
That is not an issue.
Identity card, my lord, page 26. Page 26. Annexer 7.
This is the voter identity.
Rafiqul Islam, or voter. Safir Ali Sheikh. And 8, my lord,
This is
Annexer
the-
8, Safir Ali Sheikh Javed Ali, voter ID, my lord.
And where is Annexure 8? Sorry.
Page 27.
Exhibit 8.
Page 27. That from 1966 on the same village he is residing, same village. He was born in the same village, my lord.
If we see, my lord, the voter list from 1997 onwards, is Safar Ali Sheikh, son of Jabed, age 40, it consistent. There is no issue on that. If we compare with 1997 and 2005, his age is also increasing. He's Safar Ali Sheikh, he's son of Jabed Ali here, and his age is consistently increasing. That is correct. even in 2014, Safar Ali 6 is consistent. But only issue is along with 85, where the Saber Ali was appearing with his father. So it is not consistent with 85 voter list. And if 85 is not there, the link between Saber Ali, Javed Ali is not there. So 88 voter list. From 97 also there, 97. From 97 onwards,
Family members are there.
85 proof করব না, এটি এটা বানাবো। এখানে দিয়ে হিল ব্র্যান্ড দিয়েছে না, এই সবের লিয়ে আর যত হিল সফটওয়্যার লিয়ে মানে এখানে
81% বলে একটু বুক করব
এটাকে টুবল বলে করলে টাকা কিন্তু টাকা দিয়ে দিবে। First to read, this person has to prove that he is survey done, na? Official his statement বলে কাজে বেলা গেছে। 64 statement of the evidence. It's a big money and something. Then he's taking. Check passport. It will after the
সফরালি বলে হয়েছে সফরালি নো করে কিন্তু সফরালি দুই তোড়া হলো
total is on 85 from 9.
সফরালি নো করে সফরালি যেটা
He just submit a statement on it. Stable land pay is in the example. He has a
What is the ground of rejection of the tribunal?
Under my tendency, it's tribunal. Your lordship will find page 60, my lord. The main ground is that, my lord. Six zero, my lord, last third, second, third period. Second last, second, third period. Your lordship will find the OP has not able to establish link with the projected grandfather grandmother, and father whose name appeared in the exhibit 1, 2, and 3 respectively. This is the ground matter. Why exhibit 1, 2, 3 are the my lord? Yes, ma'am. Yes, no, from my lord, last page of the page 15, last paragraph, page 59 or not. Yes, because your lordship will find what I was submitting, that is the exact position, my lord. Exhibit 1 was the 66 footer list, where grandparents' name appearing. Exhibit 70, where grandparents appearing. Exhibit 3, that is 85 footer list, where Zabed Ali, Saber Ali, son of Javed Ali, is appearing at the age of 40 years in 1985-88 footer list. Now, the petitioner has been proving all along, my lord, his son of Safar Ali Sheikh, who is appearing from 1997 only, my lord. He has failed to prove that he is son of Saber Ali, who is existing in 1985. Yes. From the record, it appears OP has project. Yes, yes. In exhibit, in exhibit 4, the name of Safar Ali Sheikh. Exhibit 4 is the Malon 1997 voter list. Son of Jabet is appearing at voter. But exhibit 4, the person whose name appeared in exhibit 3 along with OP's projected father, namely Sabir Ali, have not appeared with the petition projected father exhibit 4. Moreover, in exhibit 3, OP's projected father name is Sabir Ali, son of Jabed Ali, was 40 years old, and again in the voter list of 1997, that is exhibit 4, he is also shown as 40 years old. So he cannot be, my lord.
Subsequent voter list did not contain the name.
Name. My lord, his
But this subsequent voter list is certified copy.
subsequent voter list is, my lord, subsequent voter list, there is Safar Ali Sheikh. That is admitted position. Safar Ali Sheikh. But it is not Sabir Ali, son of Jabed Ali, who was there. Because, my lord, it cannot be the same person.
Please try to understand the query. My brother is trying to ask a question with a, it has a purpose.
See, the fact that the tribunal disbelieved this essentially means that the document is not authentic. The names of these people have not appeared. Now,
No,
the
Lordship,
names did not appear, perhaps because this was a certified copy containing only the name of that particular person.
maybe a certificate copy, maybe. This is 1997 you're talking about.
Authorities.
It is their duty to prove that if, my lord, they have other documents where the father name, grandfather's name appearing, they could have proved.
You know, Lordship, we
submitted.
cannot go for presumption and assumption here, Lordship. I mean,
We are not even remotely suggesting.
no, Lordship,
We
if,
want to know is,
correct,
supposing if there is a certified copy produced.
Correct.
And you arrive at a conclusion saying that no, the other names are not there.
correct,
This is a question of, it's a doubt.
correct.
It was open to you to call for the records from the tribunal authority.
No, Lordship, the primary duty is always on the proceeding to bring it. I mean, whatever he brings it, that has to be examined. Now, that document doesn't contain, he didn't say anything. That like, okay, I mean, like this, I have produced the certified copy, but other names are not there. That they haven't stated.
Conclusion at the tribunal.
Correct, Lordship.
So the names don't appear.
No,
Yes.
Lordship,
When the names don't appear,
so that's a doubt, Lordship.
no, that's what we are saying. Why leave it at a doubt? Why not conclude it? Supposing, let us say, hypothetically, you call for the records and you find that there are no other names or the name is not there. This could have been included in
No,
the order. That would have changed the matter.
No, that is correct, Lordship. What Lordship is saying, if there is a doubt, you could have called for it. Those things are there. But like that is not the conclusion, Lordship. Conclusion is Lordship different, Lordship.
Conclusion ultimately is that only.
The conclusion, Lordship, ultimately tribunal read exhibit 1, exhibit 2, exhibit 3, and exhibit 4.
Correct.
Now, exhibit 3 is Lordship very vital. Exhibit 3 is the voter list of 1985. So 85 Lordship will find, because this is his document. So 85 Lordship will find at page 19. So 85 voter list, the father's name is suggested as Sabir Ali.
We
So
agree
this, that correct, Lordship. So
we accept that.
that goes to the root of the matter, because this is the
No,
document.
That is what we are trying to say.
Correct.
That we so, that means you are doubting page number 21.
No, no,
We are not doubting it.
not doubting.
Tribunal.
The
No,
tribunal
tribunal
is
is
also,
not doubting that.
no, tribunal is
My
not
lord,
doubting that, Lordship.
my-
See, what tribunal is doubting is that whether Safar Ali Sheikh and Sabir Ali is the same person or not.
Exactly.
And
No,
that,
no, no.
no,
You
this
see,
is what Lordship.
subject to what my brother is saying,
Correct, Lordship.
please come to page 59 and 60 again. You see, you're not following the substance of what my esteemed brother is saying. Now you see from record, correct?
Yes, Lordship.
Now you omit all this reading, come to exhibit 1, this is exhibit 1, exhibit 2, exhibit 3,
Correct.
exhibit 4, again exhibit 4, exhibit 3, next page, page 60 is exhibit 3,
Yes, Lordship.
exhibit 4, exhibit 6.
Correct, Lordship.
Now, in this line 3, it says in exhibit 5 and 6, OP's name appeared with Safir Ali Sheikh. Correct? Exhibit 8 and 9, obviously the son of Safir Ali Sheikh. By Spencer declared the names of his father in different documents, but the affidavit mere declaration only. It has no evidentiary value.
Mhm. Correct, Lordship. So basically what I could understand, Lordship, is that he's saying that there's these two persons in an affidavit, that will not help because you don't have any document to show that these two people are same.
No, but what happens, you see, these are entries at page 67. Sorry, not 67, the voters list of 2005. There are other members of the family also.
So Lordship, ultimately link has to be made with the grandfather, isn't it, Lordship? Because grandfather voter list are 60 and 66 and 70. So linking with the grandfather, he brings in his father.
That is even not the finding of the tribunal.
So he's reading all the exhibits,
Tribunal
Lordship.
has accepted OP2's
Correct.
evidence on the ground that his name kept on changing.
Yes.
Also projected XY
Yes.
as his father. But it is Mr. YZ who has come before. That is the ground.
There is one of the ground, yes.
Primarily, that is the ground.
The only thing is, Lordship, I mean, if the proceeding could have proved that this 1985 Safir Ali is the same person who has come and deposed, that could not have been done. That could not have been done. That they are bound to do it, Lordship.
They are bound to do it,
Lordship.
but they have produced a copy.
But that's
That if you, instead of leaving it a doubt, it has been called for and satisfied that yes, these names appear. Now, you see, what I am saying is, once there is a finding by the tribunal that the names of these people which appeared in the earlier voter list is not found in the subsequent voter list, where he projects the name to be Safir Ali Sheikh. This could have been found out by calling for the records. Now, if the record comes, hypothetically, the records come, and the other names are also there, then a further question by the tribunal whether these two persons are one and the same.
Yes, I understood, Lordship, but thing is that he is the
No, that's
proceeding.
why, you see, that's why we are putting that question. That, yeah, for a reason I don't know, I am interactive. I put you questions, I put you to notice that this is the reason why I am dismissing your application. Correct. So you, supposing you are not in this side, but this side, you make your argument, I don't ask any question, and then I say dismissed.
Yes,
Correct. So this man as a witness was there in the court. The tribunal did not ask those questions to create a doubt. You see, now, if these are minor, the spelling, now you know the law laid down by the Supreme Court with regard to the difference of name. So that argument of yours with regard to the difference of names will not hold good.
No, that will not say depend upon the facts.
No, that's okay.
Because if the person have 10 names and if the person have 2 names, that also lots of
Then
varies. Lots of, I mean,
that's supplementary question.
Yes.
If he is not the person, why did you allow him to be examined in court? Why
No, no,
did the court
this,
examine?
he has he has come to depose. I cannot disallow him, Lord. How can the tribunal disallow?
Yes,
Because his name is not reflected.
imposter.
No, no,
The court ever declared him imposter?
no, but Lordship, he has stated in the written statement.
No,
Saying
I'll
that
tell you, no.
he has stated
Uh,
that his name is this, his father's name is this.
You see, few days back only in the criminal determination, we came to know that one of the witnesses examined was an imposter. In the cross-examination, it came out that she's the member of the family and not a chance witness. And therefore, the trial court, the session judge, special judge Poxo, in the matter, while recording this statement, found out it to be false and sent her to jail.
That
So if an imposter comes, then what is the duty of the tribunal or a court? That he should not be examined. So you examine him. That's what we are suggesting. You see, you examine him with a presupposition that he's a correct person.
now, Lordship, after all these things comes out from his mouth and what has been recorded and documented, and on the basis of that, one opinion has to be written. And as I
We'll
already
resume it too,
submitted,
because
Lordship.
otherwise we'll be late in resuming again. We'll take it up at 2. At 2, Mr. We'll take first that bail matters. At 2, when we resume. No, we'll take your bail matters. We'll bail because Mr. Das has been waiting for quite long time. We'll take up bail matters and then kind of continue with this. Please inform Mr. Das. Yes.
Yeah, this is second bail application, Lordship. Earlier bail order, your Lordship will find page 96 of my IA, Lordship. IA criminal 307/24.
Yes.
Page 96. First I'm taking your Lordship to the relevant portion.
6 minutes. But is it not required that the same bench take up the IS, which was rejected earlier?
In
I think
appeals,
that is the High
Lordship,
Court notification.
in appeals, also I have seen that some courts send it to same bench and some courts take it.
No, there's a notification. It should be registered before the same bench.
It is only said bail applications.
Huh. Oh, this is suspension of sentence.
Suspension of sentence.
Okay. Yes.
So this is I'm stressing. I am Lordship kindly now take up paragraph 11 page 99. These are findings regarding my appellants Lordship.
Yes.
Though the learned counsel for the applicants has submitted that there are lots of contradictions in the statements of witnesses regarding the involvement of the applicant, in our view, those considerations will be taken up at the time of final hearing of the appeal. It is an undisputed fact that due to the alleged incident, 2 persons died due to injuries sustained by them on the date of incident. It is also not in dispute that all the accused persons were present at the scene of occurrence when the incident occurred. It is true, this line is important also. It is true that the witnesses have not specifically stated the part played by the applicants individually in the alleged offense. However, it is a settled position of law that in heinous crime like murder, sexual offense, etc., proper application of mind to the relevant factors and recording of reasons given to justify grant of bail by the court is essential. We have also gone through the detailed reasons assigned by the trial court while convicting the accused applicant in the heinous crime of murder. In view of the above, without discussing the evidence in details on merits of the case, at this stage, we do not find it appropriate to release the applicants on bail. So my whole case is that, Lordship, initially in the FIR, if your Lordship see, in the FIR, it was alleged that one Hassan Ali, he was FIR name accused number 1. He shot and thereafter he killed Sohar Ali. And subsequently, other accused persons killed one of his brothers, Johar Ali. That is the case. And in the FIR also, your Lordship will find it is mentioned another Hassan Ali. name is almost same, that the assailant was Hassan Ali, and one of the witness, Hassan Ali, that is examined as PW2, he was accompanying the deceased. He informed the informants about the incident. And thereafter, this FIR was lodged after 2 days of the incident, Lordship. And even then, there was no specific allegation against these persons. And those bullet injuries, that is not found in the body of the deceased persons. And from the evidence of PW2, your Lordship will find that there was, at the time of incident, there was riot going on, Lordship. And some other persons were also killed in the said riot. So that identification of the body, that was also taken up by the defense counsel during trial, that was not considered, Lordship. Body of two deceased were postmortem on the same day, but one was sent to Dhubri Civil Hospital, one was sent to Lordship, that Guwahati Medical College Hospital.
No,
On the
but
same day,
but one of the finding is that one of the dead body,
Lordship,
which was found in a particular place,
Lordship.
was the identified dead body of a particular person. Names I would forget.
Lordship.
So this dead body was identified.
From the wearing apparels and other things, okay. That's Sohar Ali. Sohar Ali. And another aspect, Lordship will consider that if there was eyewitness to
Jahar-
the occurrence,
There's a person dead body, Jahar Ali.
Johar Ali and Sohar Ali,
Huh.
two persons.
Sohar Ali and Johar.
Johar.
Sohar Ali is beheaded. He was beheaded and he, as per one.
But his body was identified. His body was found by a river.
Yes.
Riverside.
His body was identified.
That is what I was pointing out, that the incident occurred on Lordship just on 21/6/1999, and FIR was lodged on 23/6/1999 after recovery. So 2 days after that, body was recovered. If there was any eyewitness, they could have recovered the body immediately, Lordship.
And this is for which the deceased person that they were said that his hands and legs were tied with a gamusa and then he was killed. This is
Johar
for whom?
Johar Ali.
Johar Ali.
Johar Ali.
But then there's a specific evidence to the effect that he was tied up and then killed.
No, regarding tying, Lordship, that medical evidence I do not find subject to correction.
No,
but my
medical, there may not
recollection.
be a medical evidence for the tying. But the witness says, and I don't find that this witness has been discredited for the evidence that the deceased hands were tied and then he was assaulted.
That allegation is there, but your Lordship, if your Lordship see that if they are the eyewitness,
For the purpose of determining application for suspension of sentence,
Lordship,
we are only prima facie trying to
Lordship.
see if the case is connected, not the value of the evidence.
Lordship. Therefore, I am pointing out from the initial stage, Lordship, that when FIR was lodged, they said, Lordship, only Hassan Ali, that PW2 was there. And he informed about the incident, that is after 2 days. And if those two other witnesses are there, they could have certainly lodged the FIR or informed the other
We
person.
don't know because somewhere I found that this is the riots was between the Bodos and the Santals.
Santal, yes.
And that point of time, maybe because of the situation, somebody may not have lodged an FIR. But this was a riot which had a big impact.
Lordship. But that explanation was not given because about the riot part, Lordship, the defense during cross-examination, it was brought out.
No, but even after 2 days
Lordship.
of lodging of an FIR, is it very fatal?
No, I have fatal on the part, Lordship, that they have not disclosed the presence of other witnesses. They are categorical that only PW2 was there along with the deceased, and no other person has informed the informant. It is categorized in the FIR, Lordship. If your Lordship kindly read the FIR, just I'm translated it. May I please that FIR? In the FIR, it is totally a different case, Lordship. That when, and if your Lordship see the evidence of PW2, he also said he also not supported the prosecution case, Lordship.
Yes, you want to continue?
Let him, I am here. But one thing you also should say, my lord, so for the present appellants are concerned, there is no direct role any attributed to them. Moreover, in this case, 149. Your lordship very much aware that, my lord, it must be spelled out who has whose role. Nothing is there. None of the present appellant has been attributed anything, my lord. Identity of the accused, sorry, deceased. And PW1 especially stated, my lord, there is riot in between, my lord, riot at that very time. So that bodies may be of the any other, my lord, victim of the riots also, my lord. Only two, my lord, also can this, except nobody has, my lord, implicated this person now. Your lordship that about this Hassan Ali, except Hassan Ali, my your lordship can FIR if you go again, my lord. It is omnibus statement, my lord, that all of them come. And they are saying, my lord, that as per direction of accused number 1, Hassan Ali, he is already, my lord, dead, expired, my lord. But at the time of occurrence, my brother Johar Ali started running to save himself, but accused killed him also mercilessly by sharp weapon. While searching the bodies of my two deceased brothers, one headless body was recovered at a distance nearby the river. One Muhammad Hassan Ali was accompanied with my two brothers, somehow fled away and informed me about the above incident. Now, Hassan Ali is PW2. If your lordship is a PW2 also, that also court has not relied on him also, my.
Just now.
Yes.
This matter is of three accused persons.
Yes, 3 accused.
Lalchan Ali,
Yes. Lalchan Ali, Jamaluddin. Wahab and
Ali.
Jamal. Jamal, 2 Jamal, my lord. One Jamal is Jamal Sheikh, whose name is mentioned somebody, my lord. He Jamal Ali and Jamaluddin, and that will be made clear in the FIR, my lord. Father's names are given. Both the Jamal. Only PW2 your lost kind of. He is the only person who was accompanying them, the deceased. And what he says, my lord.
just a moment.
Yes.
Yes, PW2.
Yes. He is the person who is mentioned in that he was accompanying the deceased. And he says your kind might have crossed your kind. On the day of my chief matter, on the day of second line, on the day of the incident, I along with deceased Shohar Ali and Johar Ali went to the market. On the day of the incident near about so-and-so, we came from the market, so-and-so on 64 statement. Now cross my dear Lord. The distance from so-and-so village to so-and-so is about 6-7 miles away. To reach from so-and-so, we had to travel by boat. I came to Hasri to Pur Chandrapur by engine fitted boat. When we landed to Pur so-and-so by engine fitted boat, myself and the deceased person went to their destination on different roads on foot. I came to my village by different roads, and Soharali and Joharali, my deceased, went through different roads. Later on, after 2-3 hours, I came to know that some unidentified persons had killed Soharali and Joharali. Unidentified person. आपको कोनो मूल नाम कौन है? One line more, by just continuation. Soharali, Joharali, some unidentified person killed Soharali, Joharali. At the relevant time, the incident, that is important minor. Incident, there was a riot between Santal and the borders. And for the said riot, several bodies are found dead near the Champa River. Champa River. After the incident, I did not meet the complaint so-and-so, so-and-so. So this much minor. On the basis of his statement, this FIR was lost minor.
Subject to correction because I don't remember everything I read. So far as I understand that the PW number 5, 6, and
Yes.
15, they are the eyewitnesses.
15.
And you are discrediting them by saying that this exhibit, the witness number 6, 11, and 15 are the sons and relatives of the deceased. And therefore, the
they
evidence
have
will be
come from the
discarded.
jail, minor.
Huh?
They were convicted in connection with the murder of the one of the father of the accused. They are in the jail. From the jail, they have come and they have deposed minor. This is on record.
But you gave a DW1.
Yes.
DW1 was examined by someone.
DW1, yes.
This is evidence of DW1 I have missed. I did not
But
get the
5
time
and
to
6,
go
if you
through
are
it.
lost, can you go to 5 and 6 again, minor? 5
No,
and
we'll
6.
come to it.
Yes.
But this DW1 I had not read. Okay, can you just
DW1, page, DW1 is page 47
of the paper book?
of this paper, 47.
47 of the paper book?
This compilation I have given now. This one, it is there, Martin.
In which item?
Item 4. This is.
No.
At that time also we have given. Is it there or not?
Oh, achha.
Asad.
Yes. It is there.
It is there.
Page number?
Yes. Page 47.
7.
DW1. Saeed Ali. Important.
There was no cross-examination of this witness.
Minor?
There was no cross-examination of this witness.
I do not find my here. Record is also there, but here I do not find it. Oh, no, it is there, my lord. page 50. Yes, my page 49 bottom.
Yes.
In this case, actually, Hassan Ali, my lord, his son was, yes, in a murder case, deposed on one Hassan Ali, who is brother of the accused, Shahid Ali and Shahid was murdered, killed, man. Shahid Ali. Yes. Shahid Ali's brother was killed.
But the evidence of the earlier case,
Earlier case, man, they are convicted, then they came before the Singapore court.
where is that introduced by DW1 does not introduce that.
FIR also, my God. Hassan Ali, Hassan Ali, murder case of Ji Hokol, Surya, কি যাওয়া গিয়া জেল হৈছিল তেওঁলোকক অনাগবুল এপেক্স কোর্টত কি খালাস দিছে সত্য নহয় যে শাহজামালে কিন্তু দিয়া বুলি কোৱা কথা মিছা সত্য নহয় যে তেওঁলোকে মিছা সাক্ষ্য দিছে
But this, the evidence of the trial,
yes
that was not tendered here.
PW5 course of this is there mentioned.
Course of PW5.
Yes, course of PW5, page 8 to 11.
Page
8 to 11, PW5. Yes. Course page 9, my. Everything is there, page 9. Course. Your lordship got it.
Yes.
Today I have come to depose before the court from Dubri jail. Yes. Today, my course I'm reading, page 9, my. Today I have come to depose before the court from Dubri jail as I am languishing in the murder case of Hassan President. I, along with 4 others, namely Jaharuddin, Gulbal, Abdul Batin, and Abu Sama, were acquitted by the trial court. However, the High Court has convicted us, and we are languishing in Dubri jail, and from Dubri jail we have appealed Supreme Court. Accused Saeed Ali is the brother of the Hassan President. And Saeed Ali's name, of course, they have taken. Saeed Ali movies in a case number. Oh, and Hassan Ali movies. Accused Saeed Ali is the brother of Hassan President. Accused Makbul is the uncle of Hassan President. Accused Jamal Sheikh. Jamal Sheikh is not the present petitioner either. Our case is Jamal Ud Ali. Is the cousin brother of the Hassan President. It is not a fact that the accused Ijjat Ali is the cousin brother of Hassan. It is not a fact that I have deposed shortly before the court against the accused person because we are convicted in a murder case of Hassan President. Same thing in PW6 also. Both of them came from the jail and they have deposed. Exactly same thing they have stated. PW6 also page 13, course your lawsuits. Page 13, PW6.
Yes.
Same narration, man. Page 13, course of PW6. Same thing. Today I have come from the court from Dubri jail. The rest are almost same. Man. They're not like my love. This is the. They have come in their sums. And the trial court might be basing not period 5, 6, and 15 11, 12, and 15, my. 5, 6, 11, 12, and 15.
Eyewitnesses,
Yes, that is they have stated.
5, 6.
5, 6, 11, no? 5, 6, 11, and 15. They are treated to be eyewitnesses.
11 is son of PW6.
11, your lordship will find page 22. Son of my lord, this
PW6.
PW6. Son of PW6.
And 15 is son of this is Soharaji.
And 16 is son of
15. 15 is
this is Shahar Ali. 15.
Okay.
11, you'll also got it page 22. He said, my lord, he integrated one Syed Ali and rest just all the accused is covered.
11, I have read.
So 11, he is the son of accused number PW5 man. 12 also, my lord. He is nephew of this is Shahar Ali. 12. Page 26, 28. He also did not name the present petitioners, man. Simply all the accused came and assaulted.
You see, you see to this 11 I read because of a different reason. This PW 11, he is referring to the contradictions of not saying, making a statement before the police. He did not say before the police like this, like that. That is the only cross-examination.
But even from the chief, and my only question whether any role, he has referred all the accused.
No,
And he named only one person.
That is one part. The
Yes.
second part is,
Yes,
you see, the cross-examination
that-
doesn't
that-
lead us anywhere.
That is the one. That we cannot improve now, man. That is the
No, it's I'm not question of improving. It's just an academic
Yes, yes.
because the skill of cross-examination
That's-
has to be upgraded in the district bar. Because
Sometimes
otherwise,
my lord, Dubri Bar is a very good criminal lawyers, man.
that was
My lord?
WAS.
But nowadays, I don't know, I find
No, no.
most of the cases,
No,
I
no.
find this type of defect are there.
Because what has happened that these senior people who were there, they did not leave the legacy behind. So
That is
the
Yes, yes.
though it was a good bar, Barak Valley also was a good bar,
Yes,
but
Visakhapatnam was a very good bar, my lord, but nowadays, of
now
course,
it's
so,
there's more scope to improve now.
long gap is there, legacy is not there.
Because you see, you people are, especially you have a what you call people, especially in the bar, hear you. So therefore, I think some steps must be taken through your initiative or some of the known initiative people, known members of the bar, to upgrade the lawyering skills, like art of cross-examination.
No, we tried even for the bar council, also we tried to some subject matter, criminal subject, some interaction about cross-examination. Sometimes we tried, my lord, but nowadays your lordship juniors here that they know more than what we know. They are not interested, man. Now one must have a mind to learn, man. The problem which we are finding to nowadays.
You have to keep trying to find it out.
That is the problem, madam. Once I find somebody, comes 2, 3 days, 4 days, then runs
No,
Something-
I know
That's
these
there,
limitations.
anyway, but we should not, that's half of the responsibility. We should.
In the High Court bar, we had long back, about 2-3 months back, we had a seminar on the new criminal laws, but hardly there was any attendance.
Nowadays, the time of giving license, we invite them, we call them the new entrance, my lord. Something is given, sometime your lordship also, I think 1 or 2 occasions have come.
I have come there.
At the sometime, but that is not enough time, they are very new. Just they are taking a certificate, my lord. It needs to be, might have done something, might have, that's true, my lord.
Okay.
My only argument in this case, there is nothing, it is a case of acquittal, no matter. As far as this petition are concerned, I am not saying others, my lord. But even then, my lord, dead body above so far PW2 is concerned. Who is the person who was along with them at that time? He is saying there's a riot, some victim, it is maybe victim, some other person, my lord. Anyway, my lord, I leave to your lordship, my lord, and judgment is of my lord 28/6/23. Almost 1 year back. There is no likelihood that this type of appeal will take time, my lord. So I pray your lordship kindly consider because keeping up that here, my lord.
The only thing which comes out from the evidence of PW2 is that the deceased persons was having enmity with a lot of persons.
Yeah, boss. But that too, our names are in that, not that way it has come. Especially he named somebody, my lord. And murder case is pending.
What is the evidence of PW15?
Yes. PW15, your lordship, and page
PW15,
35.
12 and 15 also claims that they
Same,
were
madam.
eyewitness.
Yes, 11 is, I remember the 5, 6, they are saying all are eyewitnesses. But 5, 6, 11, 12, 15, all are family members. Man.
All are family members.
All are family members.
But their presence in the cross-examination could not be denied. 15, I have not read it completely, but 11, 12, there.
Now, even presence is there, madam. I am saying the presence is there. Even then, the.
Huh?
Particularly name Zamal, Siraj, Hassan, and all other accused persons.
So that is what I am
it is thereby.
No, the presence of the witnesses at the place, that could not be demolished.
Yes,
That they were not present and they gave a false evidence. This impression I did not get. 15, I did not read.
But false allegation, my lord.
Zamal, Siraj, Hassan. The name particularly said, and all other accused persons, along with all other accused persons.
No, that is accused part.
What
I'm on the witnesses part.
Witness.
The witness was not there and they were tutored witness.
That was not demolished.
So the presence of the witness at this stage, that was not demolished.
I am only an interested witness one. Yes, they may be present, my lord. Whether my lord on the basis of their statement that is only one to a judgment, I am just referring subject to your lordship.
And what do you say about the limitations of the court to grant bail, to examine the evidence for the purpose of suspending sentence? What is your submission on that?
Of course, it is prima facie your lordship, because whole thing your lordship cannot go so ever bail is concerned. But what normally on the face of it were two things we find here. One is interstate witness, another is 149. Supreme Court categorically stated, my lord, everybody's role has to be discussed by the court below. And interested witness, my lord, once there are interested witness, it is to be done carefully, very carefully. I'm not saying it cannot be done, but it can be done, provided they go through it very carefully, my lord. That is just two judgment I'm giving your lordship, my lord. 2011 9 SCC 257.
Just a moment.
2011 9 SCC 257. Ramchandran and others. Ramchandran and others versus State of Kerala. Paragraph 27. Yes, idea might have some, it starts actually, your lordship will find from 17 onwards, paragraph 17 onwards. Referring so many cases, paragraph 27 is the conclusion.
This is on?
Yes.
Which point?
149.
What is the page number?
Page number, my lord, 257. Paragraph 17 to 27. 27 is the concluding part. It is 149. It's short paragraph, my read, my lord. The state course has been, yes, yes. Interactive witness law matter. ভীষণ গভীর একটু কেমন আছেন ইন্টারেক্টিভ দিছো না একটু দেওয়া হয়
Yes, the second judgment, Mr. Chaudhary.
মানে 27, just I'm reading to 4 or 5 lines.
Huh.
Thus, this court has been very cautious in a setting of judgment, that judgment discussed from paragraph 17 onwards, man. That where general allegations are made against a large number of the persons, the court would categorically scrutinize the evidence and hesitate to convict the large number of the person if the evidence available on record is vague. It is obligatory on the part of the court to examine that if the offense committed is not in direct prosecution of the common object, it yet may fall under the second part of 149 if the offense was such as the members knew was likely to be committed. Further, inference has to be drawn as to what was the number of the person, how many of them were merely passive witnesses, what were their arms and weapons. The numbers and the nature of the injury is also relevant to be considered. So from paragraph 17 onwards,
In this case, the evidence of the doctor is that they were stabbed multiple times.
yes.
That is there.
But
The weapon of assault, I don't remember whether it was
nothing
recovered or
was-
not. It was not
yes,
recovered.
It was not recovered also. And other one is my lord, just another only, I'll not read my lord.
Yes.
That 2022 live law SC 856. 2022 within bracket, sorry, live law within bracket SC 857.
Name of the parties.
The party name Muhammad Jabbar Ali and others versus State of Assam. Paragraph 48. This I have given the copy of your lordship.
Okay, Mohammed.
Of paragraph 48.
Mohammed.
Muhammad Jabbar Ali JABBAR versus State of Assam. The two appeal much. Another is Muhammad Ajmal Ali versus State of Assam. Two cases.
Here paragraphs.
48. On interested witness. Only one paragraph. It is noted that great weight has been attached to the testimonies of the witnesses in the instant case. Having regard to the aforesaid fact that this court has examined the credibility of the witnesses to rule out any tainted evidence given in the court of law. It was contended by learned counsel for the appellant that the prosecution failed to examine any independent witnesses in the present case and that the witnesses were related to each other. This court in a number of cases has held the opportunity to consider the said aspect of related interstate partisan witnesses and the credibility of such witnesses. This court is conscious of the well-settled principle that just because the witnesses are related interstate, their testimonies cannot be disregarded. However, it is also true that where the witnesses are related interstate, their testimonies have to be scrutinized with great care and circumstances. In the case of so-and-so, this court held that the testimony of such related witnesses should be analyzed with the question of its credibility. So that part, my only question is that nobody has, somebody is coming from jail, they are saying same thing, my lord. Pay out like, my lord, that they are given. At least some attribution must be there to this present, any one of the petitioners. While Jamal, my lord, friend said, one Jamal name is come, but that Jamal is not the present Jamal. Two Jamals are there. That Jamal is some appeal number. Yes. Yeah, one is Jamal Sheikh, one is Jamal Uddin, my lord.
Son of Dust.
The son of Dust Muhammad. Yes. And the other one is my lord, Jamal Sheikh, son of Nawaz Sheikh. He is not the before lordship. Other Jamal is before lordship. So this is my lord, the pure lordship, but only for the purpose of bail, I am not taking a lordship much time because other learned counsels are over there, man. Like prima facie, I find it is a case of acquittal. That is what I am saying. So I think my lord, I made out a case for granted
That is
bail.
accused number 10, Jamal Ali Sheikh.
Sheikh. Accused father, son of your lordship.
Noimuddin.
No, I am not. I am Dust Muhammad. I was actually initially my daughter. They have shown me absconder. Subsequently, I surrendered. Jamal Sheikh, son of Dust Muhammad. Okay, Jamal to Kakato.
You were absconded, thereafter it was proceeded against you.
That is that.
Huh.
Initially, that Jamal was there, mine, initially. Who Jamal, so I, not absconder, no, nothing against me. Subsequently, I was police also after me, mine. That Jamal is my lord. Jamal, it is in criminal appeal now 286, my lord. Or 258.
No, because this name did not come in page 13.
Yes.
The impugned judgment, page 13, your name is petition number 3's name is not there.
Yes, that is what I'm saying.
That's why he was absconded and then subsequently.
Okay. And that Jamal is matter that item number, it is item number. Was this the call? Oh, not Amber. Even not. That Jamaluddin, my lord.
Accused number 10.
Yes.
Yes.
Accused number,
Item number 5.
item number 5, my. That Jamal.
Okay.
Obliged to us. And all the rest.
Judgment to juvenile ground neither will be commission. May it please. Item number 6, minor. I am for one Hussein Ali. Now, previously, my lord, I moved a bail application for these accused persons also. That order, that bail application was rejected at page 102. Hussein Ali, accused from the judgment, it appears accused number 3, Hussein Ali, Akhar Ali, Akhar Ali.
Accused number 1.
Akhar Ali happens to be accused number 1, as appears from the 313 statement. There are two things. That's why I take your lordship to 102, previous rejection order. Here in previous, my lord, all the bail application was taken together, my lord. So far with regard to Hussein Ali, along with another Muhammad Mohar Ali was taken together, my lord. Mohar Ali ground was taken that he was an old man, my lord. And so far, Hussein Ali is concerned that he is a juvenile at the date of occurrence. Now, with regard to that, my lord, we'll kindly come to paragraph 8. May I read it, my lord? Page 105 of my IA. Hassan Ali, yes. Paragraph 7, my lord, may I read it? The learned counsel for the applicant submitted the applicants were co-accused along with with 8 other persons in respect of the charge of murdering Zahar Ali and Sahar Ali, who are all convicted by the learned trial court. The applicant's counsel submits that there was a delay of 2 days in filing the FIR, besides the fact that in terms of the forum used by the learned trial court by examining the applicant Hassan Ali under 313 CRPC, the age of the applicant Hassan Ali was shown to be 35 years of age in the year 2020, thereby implying that Hassan Ali was only 14 years at the date of at the time of the incident. He also submits that in the production letter submitted by the police to the magistrate's court in the year 99, Hassan Wali was shown as 52 of the 52 years of age. However, in the charge sheet dated 29/12/2000, 29/12/2000, Hassan Ali was shown to have expired. In view of the fact that Hassan Ali was shown to have expired in the charge sheet dated 29/12/2000, it could not be understood as to how the statement of Hassan Ali could have been taken under 313 in the year 2000. In the event, the age of Hassan Ali being shown as 35 in the form used for his examination under section 313 CRPC, the conviction of Hassan Ali would have to be set aside. He was a minor at the time of incident. The learned counsel for the applicant submitted the applicant Akhir Ali. Now I am skipping because I have not preferred for him this time. Next paragraph, my lord, paragraph 9. Messrs. So and so learned additional prosecutor on the other hand submits that the evidence of the prosecution clearly shows the involvement of the applicant in assaulting the deceased person whose lead to their death. As such, it not be proper to suspend the sentence and release them on bail, as their conviction has been made on the basis of testimonies of eyewitnesses who are reliable witnesses. A perusal of the LCR shows that there are 2 accused persons having similar names. That is Hassan Ali. However, the applicant herein actually Hassan Ali Mondal. Though the earlier Hassan Ali was 52 years of age and had expired by the time the charge sheet has been filed, the present applicant Hassan Ali Mondal was arrested by police only in the year 2002, wherein he has been shown to be 26 years of age. In the examination of Hassan Ali Mondal under section 313 in the year 2020, his age is shown to be 35 years and the name Mondal was missing in the form used for examining him under section 313 CRPC. Be that as it may, as the present application Hassan Ali has been shown to be 26 years of age at the time of arrest in 2002, there is nothing to show that the present Hassan Ali was a minor at the time of incident. Inasmuch as the recording of age of Hassan Ali in form number under section 313 CRPC could have been a mistake. In any event, as the applicant has not produced any document to show that he was a minor at the time of incident, the said issue cannot be decided at this stage. Further, no such stand that he was a minor has been taken by Hassan Ali during trial or even by way of an application in the present appeal. My lord, so far with regard to these facts and the last observation that he has not taken that plea is wrong. It's been plea in the cross-examination part is also there. And in the 313 itself, the court comes to that he's of death.
There are authorities which say that a plea of minority at the stage of 313 cannot be relied upon.
My lord, at any time when the court comes to
I don't know. A few days back, I read a judgment. I won't recollect the judgment, but
there are other both ways. There are judgments, my lord. What I am on now, I have preferred this bail application with the birth certificate. Kindly come to my lord at page 92. So what I am on, that let there be a medical board, let there his age may be ascertained by ossification test and all scientific examination, and everything can be ascertained. This is the birth certificate.
Page number?
92, my lord.
What is the
date of birth? Is 18/7/1982.
We can't take cognizance of this with all. You see here, the date of FIR is 23/6/1999.
Yes.
correct?
Yes.
So that means this is a document which is procured, date of issue is 10
16.
2016.
Yes.
It's procured after your conviction.
2020, my lord, conviction.
So, after your between the trial.
Yes, within the trial.
This appears to be a second issue.
My lord.
Appears
Yes.
to be some duplicate.
Remarks. Second issue. My lord, first issue, there is a son, and there is another one. Second issue. First issue, second issue. And at any stage, my lord, so far juvenility is concerned, it can be taken into. Even not been taken into during the trial. Even in appeal stage, even in SLP also, it can be taken, my lord.
But there is normally a procedure prescribed. If you
Yes.
Don't apply for the birth certificate
Yes.
within the stipulated
Of course, my
period.
lord. But that has not been proved. Suppose in a appellate stage, my lord, because it's been the law of the land that a juvenile will be tried separately. Now, even in the High Court appellate stage, it can be ascertained, my lord.
But what was the date of the incident?
Date of the incident is 21/6/99. And date of lodging the affair is 23/6/99. And he happens to be on that particular day, happens to be 16 years, 11 months, 2 days. And as for 313 statement itself, well. And my prayer is very limited. Let there be a medical board, my lord. Yes, hospital. Yes, friends.
Me too.
Coming to the substantive evidence part, my lord, there is nothing against this accused persons, my lord. If your lordship allows me to appreciate the evidence on record, I can satisfy this honorable court. Because there are two Hassan Ali admitted. Now, my lord, PW1, so far PW1 is concerned, my lord. Another accused, namely Hassan Ali, told the other accused, namely so-and-so, 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 to kill my brothers. When Zahar Ali tried to escape from the accused Hassan Ali and Akhar Ali caught him. That's all. And now, who is the person who has caught him? Because there are two persons. One was charge-sheeted, my lord. Otherwise, before charge-sheet, he expired. There is PW2, my lord, who happens to be an eyewitness. Nothing stated, my lord, against him. PW3, my lord, hostile, my lord, nothing against him. PW4, my lord, not implicated, not whisper his name. Now, PW5, my lord, he been brought from the jail. And that's been my learned senior colleague has also submitted before the court. He has been brought for jail. Now, in his previous statement, it's been recorded. In his previous statement, so far with regard to substantive evidence, the court, in the substantive evidence, he said, the other accused person, Hassan Ali, Zamad Ali, Suleiman Ali, etc., had assaulted and hit the victim by sharp weapon. As a result of such assault and hitting by sharp weapon, the victim, Zahar Ali, breathed his last. It was absent in previous statement and it's been proved by the IO. It's never been stated. And he was being brought for deposition in the court from the jail. He's a murder convict. And his previous statement contradiction has been proved by the IO. That is never stated as such. Now, another witness from jail, my lord, PW6, my lord. He stated my name, my lord, and which Jahar Ali, that has not been specified. One Jahar Ali before Sarshid, my lord, died. I saw victim Jahar Ali was running and he was followed by accused Syed Ali, Habi, Jamal, Mokul Hussain, Hassan Ali, Akhir Ali, etc. That's all, nothing else. So far, giving specific overtake attributed, absolutely silent. No specific attributed. One Hassan Ali, my lord, who has not been charge sheeted because he expired on 28/2022, 2002. And other witness PW6, my lord, he names me. To that extent, my lord, I saw victim Zahar Ali was running and he was followed by accused Syed Ali, Habi, Jamal, Makubuddin, Hassan Ali, Akhar Ali, etc. That's all. Nothing else. PW7 has been doctor. PW8, my lord, no way they have whispered, my lord. PW9, Samar Ali, not whispered. PW10, no implications. PW11, my lord, no implications, my lord. So far, this accused is concerned.
Other accused persons also assaulted and hit.
Other accused, these are omnibus statements, my lord. And Zahar Ali, who is this particular person, Zasen Ali, who is that Zasen Ali? Charge-sheeted accused is only one, Zasen Ali. And one Zasen Ali expired. Who is the Zasen Ali who has my lord assaulted? And in occurrence, date of occurrence happens to be this, and I am 16 years, 11 months, some days. And so everything will be clear by ossification test. Because I have adduced a document which is a government document. And my previous bail application was rejected only that no document I have submitted. Now I am submitting the document. And other witnesses, my lord, nobody implicated. These particular accused persons, appellant. The judgment has already done. No.
Yes, Mr. Das.
There are five cases. Five eyewitnesses and one of the counsels to the appellants are harping on the point that there are omnibus statement and no personal individual. 14-15 persons. That is why evidences of the PW's his eyewitnesses are believable. 14-15 persons who inflicted which injury, how they will, how they are expected to narrate that. And your lordship will kindly see. The evidence started after 14 years. Occurrence took place in June 99, and evidence started in September 2030. Is it humanly possible to recollect what happened exactly 14 years back?
No, but that is the requirement of law that attributes must be given as to which accused did what.
They explain possible. They have given personal attribution. It is not that there is nothing in evidence already. They have given and they have identified in the dog the accused persons, all the accused persons who inflicted injuries. And their statements, these eyewitnesses statements are duly corroborated by medical evidence. There are multiple injuries over dead bodies. For the purpose of bail, what else is required?
And what about the plea of juvenility raised by Mr.
Juvenility,
Dina?
your lordships have seen the in 2016 it is anyway, he can raise that. It is a settled law. This case, even before the apex also he can raise. But for that, so when plea of juvenility is taken, burden lies on him. Now he has produced one certificate that cannot be taken into account by this honorable court unless it is proved in evidence by them. Now, for the purpose of juvenility, before sending it to there is provision for inquiry by the session court, session judge, the high court. Before that, with all respect, I submit there should be a preliminary investigating officer, preliminary investigation by police or CID regarding genuineness of this birth certificate.
No issue.
Let the case be recorded by the concerned police station and let an inquiry
No,
report.
for that you can always make a prayer as a public prosecutor, additional public prosecutor to allow you to allow you some time to have instructions on this document.
Yes. Since this is an appellate stage, perhaps if it goes to the court, that will be better. I think.
Pardon me?
Since it is appellate stage, the case.
No, it's not an issue of that, because if you raise an issue, if you are trying to create a doubt, why don't you make a prayer?
Yes.
No, direction of the court, you see, the court cannot, the court, what do you call, unless you show me something otherwise, the court cannot make two inquiry, one by the police for the correctness of the document and to the district judge to make a assessment as to the juvenility. Two inquiry, I don't think, I have not come across. If you can show me some authority where multiple inquiries can be made.
Since there is
Because you see, there are two, there is a supplemental point which would come up. Number one, if two inquiries are ordered and two contradictory report comes, then what to do? There are contradictory documents on board. Therefore, court, at least I have not come across any authority where multiple inquiries are made in respect of one document. So unless you make a specific prayer, that's something else.
Let us go by juvenile justice act. There is provision for under section 15, I think.
That is by the district judge.
District judge.
Let that procedure be adopted. But for the purpose of inquiry, may not be granted.
No, I am not asking this. Let the inquiry be there. If inquiry is in my favor, then I will praise.
Section 15, I think. Yes, no? Sorry, 15 is in the information section. What is 7 is in there? So subsequent. It was 7 actually, subsequently perhaps. Became 16.
Right.
So 16 years, 11 months to this.
50.
Just check up the provision.
Mm-hmm. 15 is one of the provisions. Magistrate. 9 to magistrate, Dada. Magistrate power. Border power to আছে আপনার fourteen to আছে inquiry by board regarding child in conflict with law.
Mr. Bhuyan, Mr. Das, I just cursorily looked at it and forwarded the book. The power of determination is given for they are mentioning Juvenile Justice Board. They are referring to board. Now, let us assume for the time being that no, not assume. In fact, for the purpose of appellate court to take the same steps, we must have some provision in the CRPC saying that the appellate court has a power coextensive with that of the trial court.
Yes.
Because under section 386 of CRPC, you have the
Yes.
please see, it can alter the finding,
CRPC.
but power coextensive with that of the trial court.
Yes.
That we are not finding.
391 is a specific provision in appeal or revision. this appellate court act as a trial court, my lord. Two, 390.
We take further evidence.
Further evidence, yes, yes. Additional evidence, my lord. Because no purpose of law is regard to, my lord, convict a innocent or otherwise in conflict with law. So it is a specific provisions, my lord. When it's been brought to the knowledge of this honorable court, this court has all the power, even in the case of revision application also.
But we are not directing an evidence to be recorded. We
Here,
have
my lord, on the
some
basis of,
determination.
yes, on the basis of my applications, my lord is making an inquiry, my lord, to ascertain.
Okay, let us examine. We'll call it again on Friday. Let me examine the.
Yes, yes.
Come back. This you write the Mr. A. Bhuya Lanan. This is item number
6.
6. Mr. A. Bhuya Lanan, counsel for the petitioner, has raised the plea of juvenility of the appellant, the juvenility of the appellant at the time of commission of crime, alleged crime. Full stop. In this regard, we have also heard Mr. D. Das, an additional public prosecutor. Full stop. List again on make it Friday. Friday is 9th August. Okay.
Obliged.
These are all the matters, or anybody else want to address us? Yes.
Item number 9, madam.
Yes.
8 and 9. 16. 8, 9, and 16.
No, anything more you want to address? Then Mr. H.R. Chaudhary has already submitted.
No, yes, my case is totally different, madam.
Okay.
So for us, item number 9, madam, Miradul Haq, alias Siraz, madam. Yes, sir. Thank you. Yes, sir. Madam. Yes. He is accused, my lord. He is accused number 2, Hassan. His name is Miradul Haq, alias Siraz. His name is Siraz, as appeared in evidence. And he's been convicted under section 302 by 149. It has been stated that he is a member of the unlawful assembly for prosecuting a common object to cause death to Jahar Ali and Sahar Ali. Now, in this case, you will also find there are altogether 20 witnesses were examined on behalf of the prosecution. Out of 20 witnesses, my lord, there were some. Yes, please.
Sir. I 737.
Yes, please. There were 20 witnesses were examined, my lord. Out of 20 witnesses, my lord, only suitable one
who's an informant, he was not an eyewitness, my lord. PW2, my lord. He also not eyewitness, my lord. PW3 was declared hostile, my lord. And PW4, my lord. He was on cross. He was also Imam Ali was not eyewitness, my lord. The eyewitnesses are Major PW5, my lord. Rohimuddin, my lord. He has not named me as such, my lord. There is no specific act attributed against me, my lord. So far, PW5 is concerned. Similar PW6. He's also eyewitness, my lord. And no specific act has been attributed against me, my lord. Then PW7, my lord, is a doctor who conducted the postmortem examination of Sahar Ali. And PW8, Manwara Khatun, my lord. She has stated in cross-examination, my lord, that PW5 and 6 were not present at the time of place of occurrence, my lord. So he belies the evidence of PW5 and 6. Then comes PW10, my lord. He doesn't know anything about the incident. PW9 also. He did not, he comes later on, my lord. And PW11, my lord, he is the eyewitness, my lord. But he has not implicated the present witness, my lord. PW12 also. That is Sakir Ali. There is also no specific act attributed against this witness, against this accused, my lord. Then I was examined, my lord, in this case, as PW13, my lord. He is the IO, he is Jivoganta Kolita, my lord. After the examination by IO, my lord, what has happened? One Sakir Ali was examined, PW15. That PW15, he has implicated me for the first time in the court. He has specifically stated, my lord, this. He stated that in the examination sheet, my lord, specifically, I'm reading these evidence, man. I know the informant Mahir Ali, he is my paternal uncle. I know all the accused persons present in the court. Incident took place on 21/6/99 on Monday. On the day of incident, myself, Hassan, another Sakir Ali, Abu Ansar went to the supermarket. At the time of returning of supermarket, we boarded the machine boat and reached Sandipara Ghat. From there, we proceeded to our house. When we reached the house of Makbul, accused Said Ali, accompanied to Holas. Hearing this, we ran after crossing Chandipa. Accused Jamal gave a blow to Sahar with keta, instrument used for casing sea. Sahar fell down and accused Siraz gave a dagger blow on his throat. Seeing this, then, yeah, that is the language. Accused Siraz means this appellant gave a dagger blow on his face. Seeing this, Jahar Ali ran away. I too ran away out of fear from the place of occurrence. After coming to steps, Hassan Ali caught hold of Jahar, and Jahar called other accused persons who had assaulted Sahir Ali and all other accused persons present before the court between Jahar Ali. Seeing the incident out of fear, I ran to save my life. After reaching my home place, I disclosed the incident to my younger brother, Sabar Ali, and my neighbor Surman Ali and Ashraf Ali. Again proceeded to the place of occurrence. With Sabar, Suman, I did not find the dead bodies of Jahar and Sahar. Now, what has happened in this cross-examination, my lord, but suggestion was put to him that whether he stated this fact before the IO. It was a suggestion, it is not a fact, I did not state as source. But that cross-examination, that has not been confirmed by the IO, because I was already examined. No attempt has been made by the prosecution to recall the IO. That is the difficulty we are facing. Whether he actually made such statement before the police or not. Because he is the only witness who has implicated me in this case. Because in a cross-examination, your lordship, you can see, it is not a fact Sahar and Jawar responding so and so. It is not a fact I did make a statement before the police. On the date of occurrence, I went to supermarket with Shukur Ali so and so. It is not a fact I did not make a statement to police within inverted commas. On the date of incident, at the time of returning from supper, Monday market, we boarded a machine boat, reached Chandipara Ghat. From there, we proceeded towards a house, reached house of Mukbul Hussain. Accused Syed Ali commanded us to hold. Hearing this, we ran up. After crossing Chandipa, accused Jamal gave a blow to Sahar with keta. Sahar fell down and accused Siraj gave a dagger blow on his throat. Seeing this, Jahar ran away. Whole statement we have stated, we have given a suggestion that you have not stated before, implicating me as well as other accused. But that whether he had stated so or not, but that was not under section 145 of the Evidence Act. I have to prove it to the IO. In this case, I was already examined.
I heard already.
IO in this case, madam. He was already examined before examination of this witness, PW 15.
I was examined as a PW.
13. জীবকান্ত বলছি আমি। So I'm also prejudiced for, as I could not prove the witness because due to non-examination, re-examination of IO.
Okay. Okay.
There's another important member. Even if the IO is not examined, it was the duty of the court also, my lord, trial court. Because trial court, my lord, there is an express provision in the CRPC, my lord, where he can go to the case diary. He can look into the case diary for the purpose of whether that statement was made or not. Because there is a division bench, I forgot to break the decision, that is Parvati Goswami judgment way back in 1971. That court can look into it, my lord, for purpose of finding out whether
The provision is there.
yeah, provision is there. So to find out whether such statement was made or not before the police. Because there is a major omission. If that statement is not made before the investigating or during the course of investigation, that will be a major omission.
That I'll have my doubts in view of provisions of 461, because it can also be viewed in a different way, that the defense did not think it to be appropriate to recall the no application. That's why no application was filed for recalling of the IO. So it does not, non-examination later on does not vitiate the proceedings.
I'm not saying for visiting, but this is the power. The court has
No,
power.
court has power. That's true. That's true.
That is,
Okay.
in a given case. So if that statement is, if Mr. Das can also look go to the case diary, my lord. If he finds that no such statement has been made by the said witness, my lord, then I am entitled to get the benefit, my lord. Because no specific other witnesses are totally silent so far my role is concerned.
Mr. Okay, Mr. Das. You have CRPC? You have a copy of CRPC? Otherwise, take it from here. You see, I have a doubt. Please clarify. This case diary, please come to 172. One 172.2 says, any criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case, but to aid it in such inquiry or trial. Now, to aid in inquiry, what is your interpretation of this word, aid? Because Mr. Kotaki says that the court could have read it and found out the inconsistencies or contradictions. Now,
Inquiry is defined by the sentence. The word inquiry is defined by the sentence.
Huh.
Section 2.
Inquiry or trial?
Inquiry by the court.
Yes.
Investigation means investigation by police.
Hmm.
And inquiry means by the court.
Huh.
Any proceeding before the court.
So the by use of this word aid in 172.2, do you agree with this proposition that the court could have looked into the case diary to find out the contradictions? It can.
And on many occasions it is done when I stated before the division minutes before court number 1 also.
But then, no, but then there's a, no, then you see, then what happens is that the competency of the lawyer will take a backseat and everything will be taken up by the court. You see, the court does not get in the trial court, there is no assistance from the lawyer. And therefore, the burden is on the trial court to find out after each evidence is recorded, that what is the contradiction, what is not, what is there, and to bring it forth and make it a part of the court record.
It's correct.
So is that the scheme of trial, that the court takes over everything?
Appellate court is also, so.
No, it's not a question of that. The question is, somebody is represented by a lawyer or a legal aid counsel. Now, if those inconsistencies are not put to the court, if these evidences, the power to recall a witness for the purpose of contradictions are not made, therefore, the question is whether the trial court suo motu will take up these issues to find out a fault with the APP, find out fault with the defense lawyer, and then say that this is the contradiction and therefore we accept this contradiction. Huh?
But thing is that in manual, just now you will in this case you will also seen. Evidence started 14 years after occurrence. Now on many occasions I have come evidence on record that witness says no, my statement was not recorded by the police. When I examine the case, there his statements are there under section 161. And trials are also conducted under the other section.
No, I can't have knowledge of that. It is for you to tell us what is happening.
So this thing, that is why it is not
Okay.
required that we should go by the records also.
Okay. Any more submissions? No, because then we'll fix up tomorrow because we have to rise. There's a single bench also. So then we fix the matter again. This matters tomorrow. Nicely.
This is tomorrow.
Uh-huh.
Yeah, it says it was supposed to be taken up on Friday.
Friday second half.
I won't take much time, man.
No, it's not a question of
I know,
time. It's
Friday
a
second
question
half.
of the bench. There's a single bench also. Friday you want? Okay. Hmm? Hmm. Ah. Ninth. Okay.
One thing I mentioned, so for juvenility question is concerned, we have to go by the 2008, not this act, 2015.
2000 Act.
2000, and as per that, Act section 7A is the procedure.
Okay, we'll see that. That's why since we are not.
This, that provision is there.
Okay. Since we are not.
It was prevalent, because
Oh.
was prevalent, because finance took place in 2009.
No, now.
99.
No, for the you see, then again there will be a supplementary question. At that point of time, this 2000 Act was records to 2000 Act was not taken records to. Correct. Now we are now in 2024, and this 2000 Act has been repealed. I believe it has been repealed. No, it's not a question of that time. But today, when we are taking up matters on board, 2000 Act is no longer in existence. Existence is not there. The trial court at that point of time could have done it, but can now we put the clock back and take steps as per the as per this
Repeal Act.
repealed act? You'll have to address us. That is why we were not very sure, and so we posted it. This
Let me see the savings.
Saving clause, man.
Huh. Savings clause.
For those matters which are pending. Yes, that was never raised.
Never.
But at the same time, we cannot give retrospective effect of 2015 Act also. No. If we resort to 2015 Act, that will amount to giving retrospective effect to
Repeal it.
No, repeal does not. There. C69. C69 repeal provision.
That provision is there.
Repeal says not only repeal anything done or action taken, not the action to be taken. That's not saved. It does not. It also does not say that if any further inquiry is required to be done, it will be followed by the repealed act, because then there is no purpose of having a new act.
Now that is not in existence. Sir.
Then that is not in existence. So that's why we are not very sure, and therefore we postponed it. In except in 9, all other matters, you say the due to positive time, all sides are represented. Due to positive time, the hearing could not be concluded. List again on same Friday. Friday is 9th. So whatever is left, please address on 9th. It will 254 January 2.
On the Friday, all the, we should do also our part already over there.
No, but still we are having it together. Let it be, because otherwise, once the file splits, then we have a difficulty again. Because then tomorrow again, there's a difficulty in getting it restored. So we take it together and then. Your notes I'm putting in, don't worry.
Single bench item 1 to 6.
So in this case, we have filed our written list of dates on 3/6/2024. That is the record that.
Yes.
Well, we have filed our list of dates on 3/6/2024. In this list of dates, we have stated our facts here. For your lordship convenience, may I repeat it again?
Just a moment.
Briefly.
Right, sir.
List of dates. 3/6/5, list of dates.
Though it is not captioned as a list of dates, but
List of dates. List of dates.
কোনোবা এটা স্পেচিফিক কেছত আছিল নেকি বাৰু?
সবকেইটা কেছতে আছে। মই আৰু কপি দি দিব পাৰো। লিষ্ট অফ ডেট দিবা। এই ফাইল দিয়ে বাকি দাও। দি দিয়া।
No, because in none of the first, this list of dates we have seen.
In every case, there is a list of dates. Yeah, another.
1924. Record. It is not available.
No, that is a mistake on my part. I have not written is a list of dates. Probably that is confusing your lordship.
No, it's not there. Extra document is not there. In all these cases, we have four files.
Huh? Isn't down a list of bucket. In each case, I am told that in each case a copy of the list of dates has been furnished.
No, none of the matters is there because this did not come to my notice. Maybe on that day when it was not concluded, I have returned it.
That's all, no problem.
Yes. Which matter we want to take us, we want us to take us first?
1600, no?
1600.
It is the first item number 1.
Yes. It is 1600.
Sir.
1600.
1600.
Yes.
Personal difficulties which are provided in that class.
No, we have-
File a written argument.
Huh?
We have filed a written argument that is provided in that.
Anyway, he will argue later. He already argued. Because Lordship goes, it is my turn to argument. Turn of argument. He already argued the case. On that day, he made a proposal to furnish written argument. Once is your double your extra copy 9 okay? Once is double day this. Once is double year. Established. First test at Got it, Lordship? 1600.
Yes.
Now look what happened. Just let me read. 25/10/2004, 14. That is page 13A, annexer. The petitioners were Group D employees of FCI at New Guwahati. They were working in gang number 6 of that depot. These petitioners, along with the others, were subjected to a recovery from their monthly salary from the month of November 2022 in view of an audit report submitted on 25/10/2014 for the year 2012-13, 13-14. The auditor who audited the financial activities of the food storage depot of the Food Corporation of India at New Guwahati opined that the incentive paid for the period of 2012-13 and 2013-14 for rebagging by filling bags with loose grains is much more above the actual work done. The report of the auditor was only based on the gunny bags supplied from the office of the area manager. It did not consider about the repaired gunny bags. At the relevant time, the petitioners were working as Group D employees carrying the jobs of loading and unloading of food grains stored in FSD New Guwahati, gang number 6. At present, they are working FSD Hojai. That is annexer is just page 13A, this report. Here in this report, a detailed analysis has been given how the incentives are calculated. We may start it from the middle portion. First portion is a description of the godown. As per revised piece rate incentive scheme, let us start it from paragraph 2. As per revised piece rate incentive scheme for departmental workers of FCI, effective from 1/4/1998, output of gangs would be determined by total number of bags handled during the different operations maintained in FCI depot. Per capita output would be worked out by dividing the numbers of bags handled by the gang of the number of handling levers present in the gang. General norms of handling of bags below 66 kg per handling of levers per day is the following rates. No, these are not very important till then.
unloading from truck to stacking inside godown, 105 bags. That is the optimum limit. Desking into the godowns and the loading truck, 110 bags. Standardization and rebagging, filling bags with loose gains, including women, 42 bags. However, laborer would be eligible for payment of incentive wage for the output in excess of the above norms. The incentive payable for the departmental workers for number of bags handled below, these are the incentive below. Now, the crucial point is that as page 40, incentive paid against the total bags 50 kg handle is such and such and as under. How many bags were supplied, incentive paid, how many, this amount were paid, bag handle and paid. Now the auditor's report. Examination of the basic records of job performance output slips based on which wage incentives are calculated for the period October 2013, March 2014 of FSD New Guwahati revealed that huge number of bags have been shown in the output slips. That is the audit objection. As filling bags on daily basis. For filling of bags with grain, bags should be issued from the stock of gunny bags. However, examination of monthly stock account gunny bags of FSD New Guwahati for the above period revealed that the number of gunny bags shown in the stock account issue for consumption in the depot was not tallied with the number of bags shown and certified by the depot in charge filling bags. This is the crux of the case, Lord. Filling bags in output slab. There was huge difference between the bags issued for filling of gunny bags per stock account and work certified as filling bags in output slip against 57,521 bags issued for filling grains October 2013 to March 2014 as per stock account. Total number of bags filled as per the output slips 12,43,312. Thus, there were excess certification of works in respect of filling of 11,85,791 bags. Incentives were calculated and paid to the laborers of such excess work. Based on the average wage labor for 28 gangs on monthly basis, total excess payment of incentive towards the certification for filling of 11,85,791 bags as calculated by the audit was rupees 330.84 lakhs. The month-wise excess certification works relating to the filling of bags and excess incentive paid thereon were detailed in Excel. Had there been proper scrutiny of the output slips, IR section of area office, Guwahati, while calculating the incentive, such excess payment of incentive amount to rupees 330.84 lakhs could have been avoided. Management is requested to confirm the facts and figures, and action taken thereon may be intimated to the audit. Audit note number 6 dated 25/4/2014. This is the audit note. Now, this is subsequent are not very important. Now, what happened, my lord? Now, based on this audit report was given on 25/10/2014. Based on this audit report, a committee was constituted to investigate this matter. That committee was constituted on 25/1/2015. Now, my lord, a committee constituting 3 officers of Food Corporation of India was constituted to investigate the matter by the Executive Director, Northeast Region. Members of this committee is such and such, such and such, such and such. They are 1, 2, and 3. Godadhar Sheel, B.C. Das, Bhupen Majumdar, AGM, and his accounts, FCNGO. This is at page 45, your lordship would get. Page 45, 21/2015. Yes. Sri Bhupen Majumdar having designation such and such. Sri B.C. Das designation such and such. Sri Godadhar Sheel having designation. The committee shall investigate the following points raised into CAG report number such and such, dated Guwahati 13/11/2014 and note dated 27/7/2015, copy enclosed. Unauthorized payment of area wage reversion of OTI. It is not, so far this case is concerned, it is not relevant. Irregular excess certification of work resulted in excess payment of incentive to the departmental labor, rupees 33084. This is important. This is the case here. Number 2, excess payment of labor incentive due to incorrect certification of work outslip, excess payment of lead incentive due to incorrect certification of land lead, excess payment of handling incentive, unwarranted dumping, unwarranted loading. This is not relevant so far our case is concerned. This case is concerned. They were called upon to make inquiry with respect to 1, 2, and 3. An outflow slip for the month of March 2000, unwarranted loading and unloading of food grain from the same stack on the same day. Other observation based on review and so on. So we are concerned with the number 2. Regular and excess certification of work resulted in excess payment of incentive of departmental labor, rupees 330.84 lakhs. In addition to the above, the committee members shall verify the compliance of the points enumerated in FCI head cover dated such and such 16/1/2015, copy enclosed. The committee shall furnish investigation report along with the name of the delinquent officer, official involved within 15 days issue of the order. Here the committee was called upon to investigate against the delinquent official involved in this case, not the group 3, 4 not against the petitioners. Be that as it may, now 21 to 15. Now, the committee submitted report. Committee submitted report on 4/3/2015. The committee submitted their report. In this context, it was stated the excess payment was made because of their irregular excess certification of work. In this report, gang-wise excess payment of FSD of FCI New Guwahati was calculated. That your lordship would find at page 48.
40.
48. 48.
Yes.
Acha. Sir, madam, it has been pointed out by CAG during its audit at FSD Guwahati that wrong excess payment has been made to the departmental workers on account of number one, irregular and excess certification of the work of output slip, work slip. Number two, excess payment of incentive due to incorrect certification of lead. Number three, unwarranted dumping of food grains bags to earn more incentive. Unwarranted loading and unloading of food grains of bags from the same stake wrongly allowed the incentive, allowing incentive 1L an investigation. Now, Miller, here, so far our incentive is concerned, for incentive payment of incentive, nothing has been mentioned. If you read it again, irregular and excess certification of work in the output slip. This may cover. One, item number one, excess payment of incentive due to the, yes, this will cover. Excess payment of incentive due to incorrect certification of lead. Unwarranted dumping. These two is not, these two, unwarranted dumping of food grains not relevant. Unwarranted loading and unloading of food grains or bags not relevant. Wrongly allowing increments to is not relevant. At best, item number
1 and 2.
1 and 2 have some relevance. Extract of CAG observation enclosed for ready reference. And IA and PDV teams of J such and such has been sent to FSD New Guwahati to investigate the matter of excess payment to labor. And the interim report has found that the sum of the observation of CAG are in order. Copy of the interim report is enclosed. The finding of IA and PV team clearly indicates that the excess payment has been made because of the irregular and excess certification of work done, as well as the lead issued by the depot official shed in charge. Number one, shed-wise excess payment. Excess payment made in excess certification, refilling and rebigging of bags. Excess payment made, excess certification, refilling and rebigging of bags. These are the dates: March 14, shed number 1, shed number 2, shed number 3, 4, 5, etc. So grand total they have. Further clarification in this regard also be obtained from DO Guwahati in this issue. Now according to them, their excess payment 3 crores 29 lakhs 98,950 only. 3 years. Further clarification in this regard is also to be obtained from DOD Guwahati in this issue. Excess payment have been made to the department, laborers, sardars, mandals for incentive due to excess certification of rebagging and refilling bags. This is important for our case. Rebagging and refilling of refilling bags for the month of October 2013 to March 2014, gang-wise, that was gang-wise split up has been furnished. Gang number 1 to gang number 28. CPF have been remitted. The CPF have been remitted, which was recovered from the excess payment of incentive due to excess certification of refilling and rebagging bags in respect of handling work laborers and Sardars Mandal FSD for the period October 13 to October 14. Now, total remittance to such and such Guwahati, credit accounts letter number, DA and remittance. This is the total account. Excess payment, lead incentive, etc. Now, your fellowship come to page shed number 1, shed number 2, 3, 4, 5, 6. Gang wise, they have analyzed 1 to 25 gang wise amount.
1 to 28. 1 to 28.
1 to 28. Gang wise. Children. CPF have been remitted. This is one not in there. CPF have been remitted, which were recovered from the excess payment made to the incorrect certification on account of the lead FCI assistant Guwahati for the month of March 12. It is to inform that the lead distance shown at CAG is to be measured, confirmed physically at FSD Guwahati during the investigation. Further, it is for kind information that the investigation for the following points yet to be done, for which another 15 to 20 days approximately will be required. Point number 3B, excess payment to the handling incentive. Unwarranted damage, that is number 3B, excess payment to the handling work incentive. This is the pertinent for our case. C, unwarranted dumping of food grain bags. It is not important, pertinent. Unwarranted loading and unloading of food grain from scheme to shore. It is also not in this case. Other observation based on revised output slips. It is also not only one. Unwarranted excess payment of handling incentive.
Due to incorrect certification of lead.
Certificate, duty certificate, wrong certification. Okay. Next. So let me skip it. Skip. Now, immediately after this report, they have started recovery. From the month of November 2022. Based on this report, dated 4/3/15, process of recovery was initiated in the month of November 2020. Now it should be 22 or 20. There might have mistake. Achha, date. Yeah. Annexer C, D, E, F, G, H, page number 22 to 33. These are the recovery. Page number 22 to page number 33. Recovery started. This is a recovery, Millard. monthly inquiry, it is one, what is his name? Ranjit Singh. He is a petitioner here. His deduction was 26,127 for the month of December, 11 December 2020.
Page 26.
Page?
Page 26 of the
Page,
petition.
page 22.
22.
Yes. लेकिन इसमें क्या हुआ? It starts from C, D, E, F. So you can start it. It is unknown question नहीं again.
I don't count.
Huh?
I don't count.
No, this number ठीक है sir. अच्छा, now let us start from page 20. Okay. Now if you are name of this is Sirajul Kiyot, petition number 1. Now it will worship extreme right end of third row. Third. Gross deduction is 40,116. Correct.
Yes.
That deduction was made 11 December 2020. Similarly, page 21 is Ram Sagar Jadab. His particulars are furnished. If you also come extreme right at third row. Gross deduction on the month December 31,135. Got it? Third row, 1, 2, 3. Against gross deduction, gross earning is 80,749. Gross deduction is 31,135. Net payment is 49,614.
Yes.
Next comes Annexer E. He is one Ranjit Singh. Let us come to third row. Extreme right. Gross earning is 63,530. Gross deduction is 26,127. Net payment is 37,403. All these things were carried out without holding any inquiry. Similarly, in each case, Annexer F, which is at page 24, extreme right at third row, gross earning is 61,794. Gross deduction is 25,275. And net payment is 36,519. Similarly, Millard, Annexer G, page 26. Gross earning 47,662. Gross deduction 19,384. Net payment 28,278. All I have found is a month of December 2020. All these things are similar. So let me skip it up. So for the others are concerned. May I skip it up? Similar thing. So there annex 3 C D E F G H I J K L M. From the aforesaid sequence of fact, it revealed that the auditor opined excess payment of incentive to the departmental labor engaged in New Guwahati. The period of excess payment is from October 2013 to March 2014. The investigating authority was of the view that this excess payment was due to the irregular excess certification of work. The process of recovery was initiated after 6 years from the alleged excess payment. Audit report was furnished in the year 2014, and this process recovery was started after 6 years. It should be November 2020, not 2022. Yes, from the audit, from the annexes it appears, Milord. For the month of salary for the month of November was paid in the month of December. So there is a mistake in the year.
This CAG report is 25/10/2014.
2014.
And recovery started from?
From November 2020. First is 11 December 2020. Actually, this is the salary of November. Well, here just I have mentioned one thing, one judgment I have mentioned. The apex court in state of Punjab and others versus Rafiq Mucha, whitewasher, reported in 2015 4 SCC 334, indicated some of the few situations wherein recovery by the employees would be impermissible in law. 6.6 is a recovery from the employee belong to third category of the service of the group C. Recovery from the employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. I will refer the judgment later on, not now. Now, based on this judgment of a number of writ petitions were filed. Before this honorable court, one of such writ petition is Nathuni Singh Sardar and 6 others versus FCI and 6 others. WPC number 1094/2020-21. This petition was disposed of 25/8/2021. This honorable court, by his order dated that there is no material in affidavit in opposition which disclose that the petitioners from whom the recovery is sought to be made were not allowed to participate. Oh, yes. Page number
Page number
121. Were not allowed to participate in the straightway, Your Lordship, instead of reading all this way, because in my written argument I have again repeated it, that Your Lordship will find at page 121. All
126.
121, that is Your Lordship judgment. Let us read Your Lordship judgment relevant some paragraph.
26.
126. Written argument of answer. Now, in my written argument, Lord, I have pointed out the relevant paragraphs. of your lordship judgment.
Yes.
So straightway, your lordship judgment, straightway lordship come to paragraph 8 by skipping it of all. What your lordship indicated that they filed their affidavit, and in this affidavit nothing has been indicated that before resorting this recovery, any inquiry was made. Now, your lordship made an observation. Therefore, in the light of the discussion above, the court is of the concerned opinion that the action of the respondent under the facts of this case is not found sustainable on facts and in law. And as such, the court has no hesitation to set aside the action of the respondent in effecting recovery of the money from the salary of the petitioners on account of alleged fraud committed by the respondent without disclosing before the court regarding the passing of any written order to the effect. Resultantly, the respondents are jointly and severally restrained from making any recovery from the salary of the petitioners on account of the finding returned of CAG audit report dated 25/10/2014. But in the meantime, they have already recovered. The amount they have recovered, they have not refunded it. Now, your lordship come to paragraph 10 of the judgment. Now, your lordship had an occasion to make some observation with regard to the Rafiq Moshi's case. Let me read paragraph 9 also. On the facts and circumstances of this case, there appears to be no need for the court to return a finding as to whether the ratio of this case, Rafiq Moshi Supra, would help the petitioner in any manner whatsoever. As such, the said issue is left open to be decided in a more appropriate case. That was your lordship observation. Now come to paragraph 10. Before parting with the records, it is made clear that the order shall not preclude the right of the respondents to hold disciplinary inquiry or disciplinary proceeding against the petitioner and or from making recovery after giving reasonable opportunity of hearing to the petitioners in accordance with the procedure prescribed. It is also made clear that nothing contained in this order shall prejudice the petitioner or the respondent in any proceeding whatsoever, which shall be decided in its own merit without being influenced by this order. Now, you will come to my list of dates. That is,
Mr. Azuta,
Sir,
you'll be able to conclude today.
a bit difficult because it's now 4:30. 1 hour time, 45 minutes time. In that time, I have given the written argument I have placed.
Because then I have a bail matter.
Oh, sorry.
No,
That is more important.
No.
The bail
this
is more important.
No, if it is over, I can hear you. Bail can be postponed, but if it's not
No,
completed
it
today,
will not be postponed. Yeah, I cannot conclude. Otherwise, this person will be replied back.
date के दिया दिबो. Next.
তোমার নেই your bail. আচ্ছা
হ্যাঁ
8 August, your lordship has a hearing devotion bench.
Yeah.
13th.
PIL matter, 8th August.
No, that day he's not giving those days. So 13th.
Yes.
Number 3, 4, 5, 6.
No, I am furnishing the list of dates of the other cases.
Other cases.
Right. Yes, yes. जाके देखे आओ. फाइल भेज भगा दूंगा.
The other side is there, Mr. Kyal. Other side is there. You come over this side. Senior counsel is there. You can come this side. Also for 2 weeks. Then I will continue with Mr. Dasgupta's matter.
Electrification of 2 accused, sir. Thank you.
Okay, out of 3 accused, 2 applications are disposed of. You want an adjournment for 2 weeks? Okay. Mr. Dasgupta, we can continue with your matter.
No problem. Half an hour you can proceed at least. Then facts will be concluded. Not. No. Now pursuant to this, next is the aforesaid case. Oh,
Yes, please continue.
right. The aforesaid case was applicable to the petitioner of WPC number 1094/2021. This is not applicable in the instant case, but the respondent authority, without taking leave of this honorable court, applied the order of WPC number such and such on the petitioners. That is my submission. Right? Now, what happened? They have issued show cause to all persons.
Yes. It's a bail application. You said both sides are represented. On the appeal made by the learned counsel for the petitioner. List after 2 weeks on a date to be fixed by the office. Yes.
They have applied this observation on all other cases. So we have pointed out before this honorable court, and this honorable court passed an order on 25/8/21.
Yes.
Yes. And page number what was
126 to 133.
120 and 8 to now. A foreign judgment. You should tell. The line was isn't there? Page 149. Page 149. 149 tower code. One four nine. 146. Page. Yes, authority proceeded against the application number 13 on 19/12/2023, this honorable court passed an order, page number 149. No.
Order passed on which date?
1912. 19/9/20.
19?
19/12/2023. Page, sorry, yes. Relevant page is 200 to 204. Not 149. 204. 200 to 204. 200 page of passage.
Yes.
200 to 24. Now, paragraph 11. Facts has been explained. Your Lordship's order has been dealt with. Now, paragraph pursuant to the disposal of the writ petition, paragraph 5, pursuant to the disposal of the writ petition the FCI authority proceeded to initiate an inquiry against the petitioner, petitioner in WPC number such and such, and it is submitted. The inquiry since been concluded. The competent authority passing the appropriate author therein. It is further submitted by the learned senior counsel appearing that in view of the liberty granted by the coordinate bench in WPC number 1094/2020 to proceed for inquiry, the department proceeded for similar inquiry in respect of the present petitioners. There is other cases. Present, sir, in the instant writ petition and orders have been passed. Having regard to the learned counsel for the parties and upon due perusal of the pleadings on record, it is seen that the present writ petition is urged on the recovery sought to be made by FCI authority in connection with the principles law laid down Rafiq Musa. That is not very relevant now because Rashid Mukherjee, your Lordship made an observation. Now, paragraph 8. P.K. Rai, learned senior counsel appearing for the FCI submits that since the leave was granted by the coordinate bench in WPC number 1094/2021, the authorities in their wisdom decided to proceed with the inquiry against not only the petitioners of 1094/2021 as well as all other similarly situated persons, including the present writ petitioner. He, however, admits that the department ought to have brought the notice of the code or sought liberty from the code before proceeding with the inquiry against the present writ petitioner. He further submits that in view of the subsequent inquiries being conducted against the present writ petitioner and the consequential order passed the issue raised in the present writ petition is ordinarily would not require any further decision, more particularly in view of the order passed, dated 25/8/2021, passed in WPC number 2021, 1094/2021. Now, Millard, paragraph 9, para 11 is important. Let me read paragraph 8. Otherwise, paragraph 9 will be a bit not rhythmic. Having heard the learned counsel for the parties, we find that the liberty granted in WPC number 1094/2021 by a coordinate bench was in respect of the petitioner therein. The petitioner, notwithstanding that, raised the similar issues of the question of applicability of the principles of Rafik Musa Supra in the judgment of the apex court, had been kept open by the coordinate bench on its order dated 25/8/2021, passed in WPC number 1094 today. The inquiry conducted by the FCI against the present petitioner was during pendency of the writ petition being filed, while the court was in session of the matter. Such action of FCI authorities is deprecated, notwithstanding that no interim order not to proceed with the inquiry was operating. Now, notice in the matter was issued by date 22/3/2021 in presence of the counsel contesting the parties. Propriety demands that the leave of the court ought to have been taken before proceeding with the inquiry against the petitioners. Now, be that as it may, they have proceeded, inquiry has been concluded, action has been taken. So I am now not on this technical part. Straightway, I will proceed with the inquiry, the manner in which the inquiry was conducted. Now, paragraph 11 is important. Under such circumstances, we permit the parties to bring on record the notices as well as any orders that may have been passed in respect of the petitioners, in respect to the petitioners, in respect of such inquiry that may have been conducted by the FCI pursuant to the order dated 25/8/2021. All the proceedings were directed to be brought on the record. Pursuant to the order passed in WPC, the matter will be considered upon such pleadings being exchanged by the parties. Well, all that, whatever happened, you bring all these records. Now, in accordance with the order dated 19/12/2023, the respondent authority filed an affidavit to place the record. I have stated in my written argument. Place record subsequent events of holding inquiry and passing orders of the recovery against the so-called fraudulent excess drawal of incentive by the writ petitioner. Copies of the so-called notice dated 30/11/2020 are Annex B series of the affidavit as inscribed in page number 135 to 145. Now, so-called notices. My list of better category.
This is letter dated 29/1/21.
No, letter dated probably
29/1/21. There is the impugned letter here.
29/1/21. That was the impugned order initially when we have filed our writ application. some additional affidavit was filed in terms of the order passed by this honorable court. They filed their affidavit. We also filed our affidavit. Their affidavit. The lottery will get it from page 121. What is their affidavit?
Page number
121. Pursuant to the order, second order.
Yes.
Now, your lordship will find in the matter of an affidavit filed on behalf of the respondent in pursuance to the order dated 19/9/23 passed by this honorable court in WPC number 1600/2020 to place on record the subsequent events of the holding inquiry and passing orders of the recovery against fraudulent excess drawal of incentive by the petitioners. Now, in this affidavit, they have annexed show cause notices. Your lordship will find at page 134 onwards. Got it?
Yes.
Now, for the timing, Lord, your lordship may consider this show cause notice was issued on 30/10/2021 by the divisional manager. At the bottom, your lordship, he signed all the show cause notices. Same person.
Yes.
I will later on I will read the contents, but what is my technical point, I am just pointing out. Your lordship may consider my written argument.
We'll continue next date. We'll continue next date.
Not only 10 to 15 minutes in here. All right. I have to.
The submission in reply by Mr. A. Dasgupta, Senior Counsel, assisted by Ms. B. Das, Counsel for the petitioner, remains inconclusive. Post hoc. Mr. S.K. Chakravarti, Learned Counsel for the FCI is present. Next para. On behalf of the petitioners, a list of dates and a written synopsis of argument. And on behalf of the respondents, copy of written argument is submitted. The same are kept as a part of record. Next is agreed to by both sides. List on 13/8/2024.
No.
We are recorded it.
আমাকে দিছে না আমাদের একটা ইঞ্জিনিয়ার বন্ধ না ওরে ইঞ্জিনিয়ার আমরা কোথায় রাখছে বুঝতে পারতেছি রিসার্চ করে জানি
The last copy we gave you is here. You are returning it. You found it.
that is my argument.
Yes.
It is
We
not
have
because I
it.
have okay, I have lost misplaced his meter in argument.
Huh?
All that I will we shall sort it out. Look, 1 minute, just minute. My basic argument is that the person concerned who issued show cause, he heard the delinquent and he himself passed the order.
Okay. Okay.
Show cause, hearing, and passing of delinquent order.
Okay. So you are saying that he becomes a person interested.
Yes. A man should not judge his own cause. There I have stated in the written argument itself, paragraph 12.
PCB,